All right, we are back for the second half of our elections discussion. Like I said before we went to the break, just as a reminder, we have 3 bills to work through between now and hopefully 3:15 if we're to, or 3 o'clock actually, rather, if we're to stay on schedule. So the next bill for our consideration is 24 LSO 0099 campaign reporting. It looks like it's you, Mr. Anderson.
Mr. Chairman, Josh Anderson, LSO. This is 24 LSO 99, working draft 0.4. This is another bill that we had up at the August meeting in Douglas. It was amended at that meeting and then forwarded to this meeting for further discussion. What this bill does is expands the definition of organization for purposes of campaign reporting requirements. So you can see the existing definition of organization there at the top of page 2, which is already fairly broad, but then this would go on to say that organization includes any group of 2 or more persons that do not otherwise meet the definition of organization if the group pools or otherwise jointly expends funds totaling in aggregate more than $1,000, even if that expenditure is made by one individual. For the purpose of causing independent expenditures or electioneering communications in a primary, general, or special election. And then there's an exception here starting on line 15, provided that the group shall not be required to file as an organization if all members of the group are disclosed on the electioneering communication or with the independent expenditure. So that's the bill, Mr. Chairman. I take any questions.
Just trying to make sure I understand that last part where the group does not have to file as an organization if all members of the group are disclosed on the electioneering communications or with the independent expenditures. So does that mean if, like, say, a candidate, for example, is filing their report and they list out all 3 individuals, or what is it specifically referring to?
Yeah, so Mr. Chairman, so this would just be if 2 people jointly spent funds together and both of their names appear on with the communication, then they wouldn't be required.
With the communication, so
yes.
the actual mailer or whatever it is.
Correct, Mr. Chairman.
Or with and so the independent expenditure specifically saying it with the radio ad and then it lists their names. I got it. Okay.
Correct.
I was a little wrapped up in that, confused by it. Questions for Mr. Anderson? Representative Ottman.
Thank you, Mr. Chairman. And Josh, thank you. But could you, because the words are just kind of muddled to me, what problem is this fixing?
Mr. Anderson?
So, Mr. Chairman, so this was requested out of our first meeting up in Lander. And I believe that the concern was that, one person could go around, gather a bunch of money from other people, but then it would appear as if it was just coming from one individual and so there wouldn't be a way to know who else is contributing to that communication, I think was the issue, Mr. Chairman.
Yep, I think that's a good summary of it. Other questions for Mr. Anderson? All right, thank you, Mr. Representative Knapp.
So with that, Mr. Chairman, thank you. With that language, with it saying or with the independent expenditures, it doesn't necessarily have to have it on the piece of advertising. It could be filed later with independent expenditure receipt.
Mr. Anderson?
Yeah, Mr. Chairman, I believe that's true. I think the intent would be if you included those names with the actual electioneering communication, then you would not be required to file that later report.
Okay, thank you.
All right, thank you, Mr. Anderson. Secretary of State's office.
Thank you, Mr. Chairman. For the record, I'm Chuck Gray, the Wyoming Secretary of State, and to my left is Joe Rubino, our Policy Director and Counsel. Certainly understand the intent of this bill, Mr. Chairman, but I want to share some concerns I have with this bill, which essentially opens the door to a wave of uncertainty and overbreadth in reporting requirements for individuals engaging in political speech. Wyoming statute already defines what a political action committee is. 22-1-102 defines a political action committee as any group of 2 or more persons organized and associated for the purpose of raising, collecting, or spending money for use in the aid of or otherwise influencing or attempting to influence directly or indirectly the election or defeat of candidates for public office, candidates committees, or political parties for support of or opposition to any initiative or referendum, petition, drive, or for the adoption or defeat of any ballot proposition, unquote. I agree with Mr. Klein's comments, which I believe were sent to you as well, that the PAC definition needs work. And I think that's one way for the committee to go in the future to handle some of the concerns that have been raised by the Fremont County Clerk. But political action committees are already subject to campaign reporting requirements set forth in 22-25-106. While existing statute also provides that organizations shall be responsible for reporting independent expenditures or electioneering communications if they receive contributions or expend funds totaling more than $1,000, the current definition is cabined such that it includes like organizations, including corporations, partnerships, trade unions, etc. The bill's broadening to include within the definition any group of 2 or more persons who jointly expend funds, even if the expenditure is only made by one individual, is troubling, both for citizens of Wyoming trying to navigate Wyoming campaign finance law, as well as election administrators charged with enforcing it. And I have real constitutional concerns with the definition that hinges not on requiring an actual expenditure on an electioneering communication, just a pooling of money for that quote unquote purpose. And major vagueness issues, and then also connecting it to 22-25-106H, which in light of the Buchanan case has, as applied, been declared unconstitutional, has problems as well. So I think this approach has some issues with it.
Questions for the Secretary of State? Co-Chairman Case.
Mr. Chairman, I might ask the Secretary how a PAC reports to your office their expenditures if they form, and how do they do that? Because what happened in this instance was there was an organization, but they didn't have the required elements that your website requires for a PAC to file. They didn't have a treasurer, for example. Didn't have a treasurer. So they couldn't figure out how to file. They were told by the election official in the county that they needed to file. They said they couldn't file because they went to your website and they didn't have a treasurer, so they never filed. So what this bill is trying to do is to avoid a situation where if we form a PAC, we're required, which Wyoming law says we need to do, we're required to file. You can do the same thing without a PAC, and you don't have to file. That doesn't seem right either. So help me there.
Yeah. Well,
Mr.
I'm
Secretary.
going to turn this over to counsel in a second. He's sort of taken the lead with our tech department on implementing SF40 from the 2023 session, which I know is near and dear to your heart. So he's been working and connecting our state PAC filing with the federal, with the requirements that are in SF40. So has become really a master at that. But yes, there are, and that's all statutory. And so that's why I'm saying if we want to address this issue, maybe we need to go into the definition of what of PAC and address it that way, rather than have this weird carve out connecting it to 22-25-106H, which as applied has just been declared unconstitutional, and creates this pooling standard, which is very odd, and then also has this provision on not requiring an actual expenditure, but just a pooling of money for that quote unquote purpose. But understand certainly what you're saying. I'm not sure this is the right way to go about it. I guess your next question would be then what's the right way, but say not this bill. Well, we'll turn it over to our counsel.
Mr. Urbino?
Thank you, Mr. Chairman. I can speak a little bit to that as we've been dealing with the implementation of Senate File 40 from the 2023 legislative session. While that dealt with federal PACs, it also dealt with some of the similar issues in grappling compliance with the statute, which now federal political action committees which do expend money on state or local races will be subject to the same political reporting requirements, the campaign finance disclosure requirements that previously only Wyoming political action committees were. In delving into that, what we were grappling with were the statutes that required the formation of a political action committee. You also have the definition of a political action committee, which the secretary has just gone through. If you fall within the ambit of a political action committee, which may or may not be true depending on what it is that you are doing with your funds, you will be subject to the state and local reporting requirements. So what are the state and local reporting requirements? Well, I don't have them in front of me. What they have is they have a provision. It's different for the state filing requirements. The state filing requirements, as you alluded to, you have to create a political action committee. These reports are submitted electronically to our office through our PAC formation wizard. That's what we call it. And yes, if you're a political action committee, if you fall within that definition and you are engaging in activity which subjects you to the political reporting requirements, then by statute, your reports to our office have to be signed by the chairman and the treasurer. So if you are subject to the requirements, the disclosure requirements, you are a political action committee under the definition, you have to follow the reporting requirements. So you have to submit it. You have to set up a requirement under, or you have to set up a political action committee under our existing framework, the statutory framework. And it has to be the report that's submitted to our office or to the county clerk's office. If it's for a local race, county municipal race, those have to be signed by both the chairman and the treasurer.
Co-chairman, Case.
The organization that did these expenditures didn't form a PAC. They were told they should form a PAC. They were told the law requires them to form a PAC. They didn't do it. Where were you guys to help in that situation?
Well, Mr. Chairman,
Mr.
first.
I know you weren't elected yet. I get it.
Yeah.
Mr. Secretary.
Important caveat. Mr. Chairman, yes, we were not elected yet. I would say as well that this sounds like an enforcement issue at the time, not an issue that warrants creating a new statute, which creates more vagueness issues, which frankly our campaign finance infrastructure is riddled with vague provisions in light of First Amendment precedents in this area. So it sounds like more of an enforcement issue.
Remind me, Mr.
Senator Scott
Secretary,
has his hand.
what would, if you had been in office and this complaint had come before you, what is the consequence to a group of individuals that don't file as a PAC but have an independent expenditure in a campaign?
Mr. Chairman, we can issue that civil fine.
Oh, that's
$500.
$500. Senator Scott.
Mr. Chairman, question for the Secretary of State. I think I share some of his concerns with the bill as it's drafted now. As I remember the discussion, it was essentially a group that was a good deal less formal than a PAC typically is. Wanted to express, I forget, it was a race or an issue that they were express an opinion on. what would happen if instead of amending this subsection H, which has its own set of problems and we're going to have to work on, we simply put a exception to subsection H in that would say, yes, one of these less formal organizations can do it as long as they put the names of all their members on their election communication or whatever else they're doing. Would that solve the problem and leave the issues on what an organization is and amending that piece of statute for a different time when we're better prepared to deal with the whole lot of it?
Do you have an opinion on that, Mr. Secretary?
Mr. Chairman, I'm not a big fan of that provision, which I did not discuss in my comments as well, with that provision that provides that carve out and allows individuals to list every single member. I think there's grave constitutional concerns with that. Mr. Klein's comments bring that out. I also struggled a little bit. I think the internet connection wasn't super solid, but I think that was the thrust of the last half of those comments. But certainly, Senator Scott would be happy to look at any language and weigh in on any language to try to make this work.
Representative Ottman?
Thank you, Mr. Chairman. Just a question. So we have a group of zealous citizens, and they want to promote somebody on the school board or support something. So they have to know that, I mean, they can't just gather up money and buy some flyers or something. They have to formalize a PAC. Is that what I'm hearing? Or do I just not get the gravity of it?
Mr. Rubino?
Thank you, Mr. Chairman. Representative Ottman, I don't know if I understand your question. I mean, yeah, if you fall within the definition of a political action committee, which the Secretary had read out, if you are, it already has this part within the definition, if you're collecting or spending money for the use in aid of or otherwise influencing or attempting to influence directly or indirectly, and then it goes on the election or defeat of candidates for public office, ... then you would be subject to the political action committee reporting requirements that we have set forth in our statute. So I don't know if that answers your question, but it depends on what you're doing to raise the money for. Obviously, we have different exemptions throughout our campaign finance law for commentary, for other things like that, and there's
May I ask questions, staff?
Please.
Josh and Lucas, could you help me find the place where there's a different statute that says if you make an expenditure, you have to report the expenditure, and then there was an exception. And I'm trying to remember which one that is. Yeah. And what I'm trying to bring out is that at a high level, in an election, you're interested in who's spending money one way or the other and where that money's coming from. At a high level, you don't care what the organization is, really. You don't care if it's a PAC. You don't care if it's a club. You don't care. But Wyoming law says you have to form a PAC. But it also says it in a different place. And have you found it? Yeah,
I think so, Mr. Chairman. I think you're thinking of 22-25-101C, where it says any organization that receives contributions or expends funds totaling in aggregate more than $1,000 for the purpose of causing independent expenditures shall file a statement of formation for the purpose of filing campaign reports in accordance with 22-25-106-8.
Thank you, Mr. Chairman. May I follow up on that? So we already have in our law that says if you spend more than $1,000 on to influence an election, you need to report. But it says you have to do it in an odd way by saying you have to form a PAC. Now, what is accomplished by forming the PAC? That means they have to have a formal structure, a treasurer, and different things. You can't even go to the website and make a campaign report if you don't have a treasurer, because you don't have a treasurer. But we don't care what form they use. We care about the expenditure. I think it's a good elections tenet that we care who's spending money to influence elections. And there is an exception somewhere about if you disclose who it is and it's by the family or by an individual. An individual can read a newspaper ad and say, I don't want you voting for Jared Olson, sign Cale Case. And I don't have to form a PAC to do that. But in the law, we say any organization that spends $1,000, and essentially other than those individuals, has to file. But you have to do it in this torturous way that you have to form a PAC first. And I'm saying that's not necessary. We can just catch all with this bill that says, if you spend the money, you should file something, you should report it, unless you disclose it. And the principle here is that disclosure is a good idea. If they put up an ad, say, we're against Cale Case, and they sign it, they don't have to do a report. It's obvious. So that's the good government principle here. And I'm feeling like we're pushing back on a basic principle that we've all supported. If we want to have anonymous contributions and anonymous expenditures and Katie bar the door, then get rid of PACs and get rid of all the other requirements. Just let people make expenditures and not identify themselves. But you can't have it both ways, and you can't let them, if they don't follow the rules about forming a PAC, they can do the exact same thing that a PAC did. That's a loophole that I just can't think we can go down that road. We didn't know that was a loophole till we got to that point.
So what would be the incentive to even create the PAC? You could just your group could just fall under the organization definition every time. If you have more than 2 people and you're collecting money, why form a PAC?
Mr. Chairman, I'm not sure you need to form.
Yeah.
I'm not sure I care. I think it
Okay.
was an unnecessary level. But sometimes people create PACs for legitimacy, to gather money from others. It's like invest in my corporation, sort of. But it's not really necessary for a small group of people that just want to pool their funds and do this. We're saying you should report the same as anybody else. And that's kind of the tenet of where this came from. You could go down the road of saying, no, you have to form a PAC. We're going to make it easier to form a PAC, and we're going to raise the penalties about not forming a PAC. And that's the way we're going to handle this same problem. Or you could handle it this way by saying, if you don't form a PAC and you still make these expenditures, you should still report, because it's in the public interest for fair and open and honest elections. That's where we're at.
What's the penalty for violating? Is this just fall under the general penalty inside the election code? At misdemeanor 750? Josh?
While he's looking it up, I guarantee you that if you have a group that is not forming a PAC but is out against you, and they're making expenditures and raising money just like a PAC, and you have them against you, you're going to pay attention to this issue. I guarantee you. And it's in this time of dirty elections and less than full disclosure, and frankly, obfuscation of the facts, disclosure might be a good thing. And Senator Scott's got his hand back.
Mr.
Yeah.
Chairman, I do want to.
Let me go to the secretary, then I'll come back to you, Senator Scott.
Mr. Chairman, I just want to make sure we're clear. We're all for having a robust campaign finance system, but it does need to be constitutional. We've just had a key provision be as applied declared unconstitutional, in addition to the buffer zone case, which is a little bit of a different situation. But since Buckley v. Vallejo, there's approaching 50 years of precedent dealing with the tension that Senator Case brought out, that tension between the First Amendment and freedom of speech and that disclosure that is important. So,
Senator Scott.
Mr. Chairman, question for Senator Case, because I didn't fully understand what he was saying a moment ago. In one of these less than formal situations where a small group of friends is putting together money and spending it, is it your view that if they simply disclose on the ad or the letter or whatever they're doing who the people are and give their names, is that adequate? Or do you also want to see them reporting the total expenditures to the Secretary of State's office?
Senator Case.
Mr. Chairman and Senator Scott, in the case of an ad or a billboard, I think the names are adequate because you could figure out what those expenditures are. You know what an ad costs roughly. I mean, you could go find out. In the case of a campaign where you don't have, you don't have a way to calculate the magnitude of the expenditures. I'm not doing a very good job with your answer, Senator Scott, but it seems like there's a situation where there's an advertisement in a newspaper is obvious. Everybody knows that the guys at the coffee shop put their money together. The ad costs $1,000, full page, and their names are on it. That's perfectly adequate. In the case where there's an entire campaign, I'm not sure if identifying the individual components is sufficient, but it might be, Senator Scott, it might be. But I suspect there's, especially in the internet world, I think it's kind of hard to label everything in all circumstances. But in a case where it's a campaign expenditure for advertisement and you can put your names on it, perfectly adequate.
Senator Scott.
Mr. Chairman, I've got an amendment prepared that would implement just make an exception for a small group that put their names on all their communications. But I'm rapidly getting convinced that this is more complicated than that. And I think maybe we're better off at this point saying this issue has got ramifications, there's constitutional ramifications on our existing law with regard to PACs, and maybe this whole subject isn't quite ready for prime time and ought to go over to the general session.
All right. Mr. Co-Chairman.
Is there a way to, staff of Josh or Lucas, have you guys thought about the implications of this with respect to the gun owners' decision that just came out? Is there a connection? What would it be? That was about disclosure of the members. And that was previous Secretary of State. And is there a connection? I'm not entirely sure there is, but I'm not positive there isn't.
Mr. Anderson.
Mr. Chairman, yeah, I think they're definitely related. I think this would be distinct from that, but certainly, depending how this was, to the extent that this could be vague or something, could potentially have an as-applied issue that was raised in that case. But they are slightly distinct issues. that was kind of a very specific portion of the statute that the court seemed to focus on in that case. That wouldn't be necessarily at issue here, but this would certainly bring more people, potentially more groups, into the needing to comply with that section. And also for the previous question on the penalty, there is a misdemeanor in 22-26-112 that does apply to any violation of Chapter 25. And then there are potentially some other civil penalties that could apply depending on which portion of the statute might be at issue.
I think Barlow's trying.
Senator Barlow.
Thank you, Mr. Chairman. So while the Secretary of State's office up here, so when I read this, getting away for a moment from the group, 2 or more persons, et cetera, organization definition that we're adding in here, this is very specific to independent expenditures or electioneering communications, which are also defined in statute. So those, and there are also exceptions to what is not an independent exception, expenditure, et cetera. So both of those. So my question is, let's take something very recent. There are mailers going out with no attribution to who's paying for them right now.
Mm-hmm.
And are those either independent expenditures or electioneering communications? Now, and the second part of that question is do you need to have a complaint to actually take one of these up? I know there are some complaints. Some have been referred from your office to the Attorney General's, but there are other communications going on. So out there, some of them in my own community, so I have seen these. And so my question is it the communication, independent expenditures and electioneering communications definition that also needs to be looked at in context of this discussion? 1, and 2, do you need a complaint to actually investigate something that may be out there? Thank you, Mr. Chairman.
Mr. Chairman.
Secretary Gray.
Let me take the second question first. The practice of the office, as we understand it, and the practice of our office in the first 9 months in concert with the statute is that a complaint is required. We have received a complaint, I think, in the case you're laying out, and we are investigating. I don't think it would be appropriate to lay out, while we're in an investigation, the exact facts of that case. I can tell you, though, I mean, and it gets to the exceptions that the Chairman Case was just laying out. I mean, there's a temporal exception on electioneering communications, which is 30 days before the primary, 60 days before the general. There's one on the referendum that is important to note. And then you also have the commentary exception and the fact that we aren't in an election period. Those are all things to consider in the context of any mailer that were to go out right now. And I assume you're talking about the Crago mailer, Representative Crago mailer. But you know, you're not in an election period right now. And that's a key distinction. And if you're going to try to catch that in, boy, that's one that's going to have some added constitutional questions.
Mr. Chairman.
Co-Chairman Case.
So, Mr. Secretary, kind of putting myself in your shoes, and it's we don't always see eye to eye, and that's okay, but we're on the eve of an election. Okay, 2024 is going to be election year. You remember 2 years ago? You remember how bad it got and how people were assaulted by anonymous things, and all our citizens were complaining about the tenor of the election. You know, and some of you were affected by it. Right now, what I heard Mr. Secretary say was, well, I wasn't the Secretary of State then. I will, and they didn't complain to me, but they are required to follow the PAC, for example. And that you'll enforce that. Is if I'm overstating, that puts you in a really rough situation as we go into this election and people see a loophole where they don't have to form a PAC and they don't have to report. And we go into what could be, with the tenor of our country and the tenor of the legislature, one of the nastiest elections that we have seen. And every one that I've familiar with in the past several years has gotten worse and worse and worse. Now, are you saying, Mr. Secretary, that you don't need this bill, that you can enforce the PAC requirement even if it's a group that didn't form a PAC, you can get them to make them form a PAC. You can threaten them. You can get the reporting so that we have a clean and fair election. Are you really saying that, or do you need this bill to help? This is helpful.
Mr. Secretary.
Mr. Chairman, ultimately, this is up to the county attorney. In the case in Fremont County, that they decided not to pursue it. I'm providing my comments as the Secretary of State, which is that I agree we need more clarity. I don't think this bill gets us anywhere in that direction. I think it makes it totally more unclear, and I stand by that comment. Now, in terms of a comprehensive campaign finance rewrite, which is a big haul, and I think that some of the comments that this bill predicated and brought out, I think laid out some of the things we need to do to move in that direction. But this bill is certainly not doing that. I think it's just making it more confusing. So I mean, and that's what my comments are related to.
Mr. Chairman,
Senator
I'm
Case.
confused about the role of the county prosecutor and the role of the Secretary of State's office. Because I believe you said that you thought that a complaint was made to the Secretary of State's office in this situation.
Yeah, it's, Mr. Chairman, there are different situations. So a
Okay.
complaint can be filed with the Wyoming Secretary of State's office, which I don't believe in the case in Fremont County occurred. I was not the Secretary of State at that time. I think the county clerk in Fremont County decided to pursue it, and the Fremont County attorney said that it was not actionable. I don't think a complaint was ever filed. Not 100% sure on that. If it was, either they referred it or they did not to the appropriate prosecuting authority, and then the same thing happened. They decided not to pursue it. But I have referring authority when a complaint is filed if I determine it has merit. But then there's also authority through the county clerks as well. Frankly, in this situation, the Fremont County situation, it really was more under their jurisdiction.
She can speak for herself.
Yeah.
Representative Ottman?
Thank you. Looking at this, and maybe it's going around the other side of it or whatever, but I thought when this topic was going to be brought, it was because there was some people that gathered together to be active, and they were told, well, you don't really have a PAC, but you have to do something. And so I thought that what we were going to try and do was make it so that these people were compliant in what they were doing, so that it wasn't because they were nefarious or because things are going to get ugly, because things get ugly. But it was to help citizens that want to be involved in the political arena to know if it was a small group and they weren't going to have a treasurer and do all this, do they have to have a PAC, or is there something that can be done to keep them compliant with law and not be in trouble, but not have to do a PAC? And that's what I thought. That's where I thought we were going with this. And maybe I'm wrong, and maybe we can't do that. But that was the intent that I thought this bill was supposed to have.
Senator Case?
Mr. Chairman, I think that's accurate in the sense that our law says you have to report expenditures, but current law says you have to form a PAC and report expenditures. And this, what this bill does is say, yeah, you still have to report unless you identify everybody, but you don't have to form a PAC. So it actually makes it easier to comply. That's the way I would suggest. I think you're exactly right.
Senator
What we
Bartlett?
don't want to create is, I'm sorry, just
Go
one,
ahead.
is a situation where now it's clear that in Wyoming, you don't have to form a PAC to do expenditures. And on the eve of an election year, because I don't think that's a signal that we want to send at this point in time.
Senator Barlow?
Thank you, Mr. Chairman. And I do appreciate the temporal nature of elections and reporting requirements. But so to, I think, Representative Ottman's point and the good chairman's point, Even a political organization is 2 or more persons, the way this bill draft is. So is a political action committee. Maybe it's easier just to go back and say 1 or more persons organizing as a PAC, then everybody falls underneath it, still within the temporal time frame, and it applies to independent expenditures and contributions. Sorry, I don't have it pulled up in front of me, but maybe that's another approach that gets to the PAC thing. And then, of course, the Secretary of State's office will have to adjust their website. There's only 1 member. Say we only have a single member PAC. Thank you, Mr. Chairman. Just as thought, as I read the 2 bills and the definition of a PAC, maybe we're creating more here than we need to. We just go back and change the PAC definition to 1 or more persons.
Mr. Chairman, that would work if we are going to enforce that if you make expenditures and you don't have a PAC, that there's enforcement about that. Yeah. So if we pull our money at the coffee shop and we take out a bunch of radio ads, we don't disclose, then we don't have to report that. That's a problem. So disclosure's got to be the high bar here, right? If we all agree on that, if we don't agree, and some people don't, people think anonymous is okay, anonymous communications, all that, but if we want disclosure, and how do we make sure everybody comes under disclosure in a fair manner?
Mr. Chairman, I do want to make a comment on that. I think it's disclosure in line with the First Amendment. I think that those last 5 words are very important. 6.
And Mr. Chairman, I don't disagree with that, but I don't know. I understand the gun owner's case a little bit, but not enough. We haven't had an analysis of it, and I fail to see as I recall, it was not related to elections, and this bill is about. Let me just read it here. For the purpose of causing independent expenditures or electioneering communication in any primary, general, or special election. So this is tied to elections. Are you with me on that? And so it's a vote for Joe. Don't vote for Joe. It's kind of tied to the election. Support this candidate, don't support that candidate. And I think those have survived First Amendment challenges in that instance. So I'm a little bit out of water here, but I think that narrow purpose, we can require disclosure, and it's in the public interest to require disclosure. It's not in the public interest to allow and expand a loophole by not closing something that has become apparent to the legislature. But I don't know if the Fremont County Clerk's going to tell us about the circumstances. It might be worthwhile to hear that. I don't know. Thank you, Mr. Secretary.
Ms. Freeze.
Reason I came all the way to Cheyenne, right? Mr. Chairman, Julie Freeze, Fremont County Clerk. Thank you for looking at this bill, first of all. And what I thought when I brought it to you, it could be easy. And every time I think that, then we can go on a 5-hour discussion about it. So quickly, what the instance was that this person told me, actually, let me back up. Somebody had complained that in an advertisement in the newspaper, it said, vote for 2 candidates, and it had paid for by Citizens for, I don't even remember what it was called, but it just said Citizens for such and such. And so somebody called me and go, who is that? And I said, I don't have a PAC by that name, so I don't know. So when it came time for everybody to file their receipts and expenditures, as you all know, everybody in our world in Fremont County, if you don't file, we have what's called a list called the Wall of Shame, and we post it outside that says who didn't file. and then we send it to the news media. So they picked it up, and I got a call from the person who was in that organization. And they said most of the money was mine, and there was a group of us, and yes, I received money from other people, but most of it was mine. And we just wanted to get together to do that. And I said, well, that's called a PAC, and you should file. The problem with that was one was a legislative candidate and one was a county commissioner candidate. And I said, well, you should file with state and you should file with me, and I'll help you out with the forms if you want to come down. They called me back and said, when you go online, if you don't have a chairman and a treasurer, which I don't, then you can't, it won't even let you go through. And I said, well, can you call the Secretary of State's office and just say, can I file by paper? And apparently that's not an option for you all, so they could file. And I said, you know what, that's not my area. I guess I'll stop there. My area is county. I can file by paper. And again, I believe you should do that. There was a conversation with my county attorney who said, if they don't have a chairman and a treasurer, you can't make them file. And I kept saying, can you just tell me, if you're the chairman, give me a disclaimer. I didn't know the law, but I want to report. And again, my county attorney said, you can't make them do it. So there I sat, not being able to do it. And I had people complaining to me about it. So it's still on my list of some people who have not filed. I've had conversation many times with this person. They're not going to file. So what I asked was, you know, how concerned are you? I realize this was a small situation. And I've given you twice now the analogy of next time I run for office, I'll just have my husband go out and have the coffee shop and the whatever, and they'll take out money, and you can get corporations. I don't know how many times you've received a check and you look at it in some corporation and you go, oops, I can't take that. I mean, that's not unusual if you don't pay attention. So do you guys care? Do you care? Do the people that you're, running for office? I think the public does care. They're calling me saying, who are these people? So I wanted to find just some way that you can file if you don't have what you're supposed to as a good citizen thing. So is there something that my original thought was, could the Secretary of State's office just change the system and allow you to file? And maybe an explanation line that says, I didn't know the rules. I have a chairman, that's me, and an explanation that I didn't do it right. And then from then on, they know. Is there a way to just change this to say similar to what Senator Barlow said, one or more people? And again, you can have one way of saying, I'm responsible, and here's all the people that, that gave money to this. I think that's the best I can do to try to make it an easy thing. I'm not sure that this is exactly what we want to have happening here, because it's either or. And again, I can see some, well, I didn't know that I could do either or. And what's an independent expenditure? Is that a new category? Instead of a PAC, it now says independent expenses. And what does that mean? I think a PAC is a PAC. I don't think the statute is bad. It's just how we're accomplishing getting this information. And it just cracks me up that we can't help people who said, I didn't know, do the right thing. How hard is that? And in both of my situations where you can't file online, but you can't call the Secretary of State's office, not these guys, but anybody before that, and say, here's something I want to report to you so you can report to the public. And the same thing with me, just come down. I will even help them fill out the forms. I just don't know why that's so hard. So I think we've made this really hard. And I don't know if what I've suggested is an easy fix or not.
Mr. Chairman.
Ms. Freeze, I think the more that I think about this, and the more that I watch this dialogue back and forth, I think Senator Barlow is probably right on the money with the solution, because the solution is how we're defining a PAC. These individuals in Fremont County, it's a tremendous loophole to say that all I have to do is say I don't have a treasurer. I don't have a treasurer, but I collected $20,000 and I spent it in an election, so I'm not a PAC. Sorry, I don't have a treasurer. That's the problem is that they are a PAC. They were a PAC, and they should have been instructed clearly that they're a PAC, and they should have had to find a treasurer and list out their officers and form the PAC, because they were a PAC. But if our definition of a PAC isn't simply that it's one or more people, two or more people, or whatever. I think that's really the heart of the problem. And it does come back to enforcement. I do agree with that as well. So, I mean,
Can I tag on to
sorry,
you,
go
Mr.
ahead.
Chairman? I think kind of on the right track. What we've done in our minds is we say, well, you have to form a PAC. So there's this deal where you create this thing called a PAC, and then the reporting falls out of the PAC. And this bill was trying to say, well, if you do the activity, we want you to report whether you have a PAC or not. And so what you're saying is you tighten up the law that says you can't make these independent expenditures except by a PAC, and I guess put some teeth in that. But I'm kind of afraid people, they'll just skip the step of filing the PAC if we allow them to do that, if there's not big consequences of that. And that sounds pretty heavy-handed. And if
No,
I could,
just the fine.
yeah, to Ms. Freese, it's more than independent expenditures because it's independent expenditures or election communications. So it's regular electioneering activity. And just one more point that I would like to make. This same group was connected with something that had statewide ramifications. And if you all recall, there was something called the Save Wyoming Rally. Do you remember the Save Wyoming Rally? There's no reporting from anybody about the Save Wyoming Rally. We know that there were more than $1,000 in expenditures to put on the Save Wyoming Rally. And if you recall, that was a pre-primary event where Republican Party officials attended and selected Republican candidates were invited to attend and rally. I say in violation of the law where the parties must be they have to be neutral up to the primary election. That was an integral part of the Save Wyoming rally, but the sponsors never had to report anything about the expenditures for that. And that was a statewide event. So this is of serious consequence, and we are on the eve of an election. So fine, we could change the bill to say a PAC is anybody or than one person, but it has to also say that if you don't formally form the PAC, you're still a PAC. You're considered a PAC. Because right now, to make a PAC, you have to register the PAC first. And that's a step. But what if you don't take that step? So it's got to be something like you shall be considered a PAC if. I'm okay with that. That's a great way to skin that same thing. But we have to do it this election year.
Mr. Co-Chairman, a PAC by Wyoming statute means any group of two or more persons who are organized or associated for the purpose of raising, collecting, or spending money to influence an election. That's
That's what it is.
that's what it is. And that's what this group was. It was a group of people who associated to influence an election.
I agree with you completely, except for when they tried to formalize the PAC. Somehow we've taken that piece, and at the Secretary of State's office previously, we required officers, treasurer, we required kind of something similar to a corporation filer. And it's that, and then we've begun to associate the piece at the Secretary of State's office with whether a PAC exists or not. But the truth is, you're exactly right. But even our prosecutor missed it.
Prosecutor definitely missed it.
Yeah, because he said they don't have to do it because they don't have a treasurer. Well, we need some help and clarity.
I like what you said, that because you don't have to change the number of people. It's two or more persons. That, I think, by definition is already there. But when you said, even if you don't file as a PAC, you're considered a PAC if you meet the definition of a PAC. Something to that extent would capture these individuals under the provision.
That's probably a good solution. I think it incorporates Senator Barlow's idea, except for the one or more.
Mr. Chairman, the only thing I don't want to do is those people who are definitely PACs, as you mentioned, the $20,000 thing. I mean, you definitely want them to continue to file legitimately. You know, we got a chairman, got a treasurer, we're active. You know, I think, I don't want to downplay that. So now that somebody goes, oh, great, we don't have to do that anymore. So I don't know if there's a minor PAC and a major PAC where you could have one or more for a minor up to a certain dollar amount. Now, of course, they would know that ahead of time, but maybe, or I don't know.
Well, I think the real true formal PACs will continue to form as PACs because they get a protection under the law. If we go forward with this organization definition, it requires a disclosure of all your members. PACs aren't required to disclose who all their donors are. They're protected from doing that. In fact, that's the WIGO case, right? It
PACs
said-
don't have to say who they got their money
I
from?
think it's because they were outside of an election.
So only outside of an election.
I think
believe
that's
so.
the gist of that case, but I'm looking around for help. Mr. Robino, get some help on that?
We've referenced it now a few times, so I guess we better
Yeah.
know what we're talking about. The WIGO case.
Thank you, Mr. Chairman. Joe Rubino with the Secretary of State's office. Yeah, to answer that specific question, and there's a lot of questions that can be asked, on that piece, but no, it was in the lead up to the 2020 primary election.
Right. So are you familiar with the holding in the case?
Uh-huh.
So does it only apply when the requirement that a PAC does not have to disclose its financiers is that was only because it was a non-election year. If it's in an election year, a PAC has to disclose all of its donors? Or
Mr. Chairman, I'm not sure that I understand. It was slightly different, right? Because Wyoming Gun Owners is an advocacy group. They fell under the ambit of an organization, not a political action committee. And so it dealt with reporting of their donors for purposes of an electioneering communication. So slightly different than a political action committee.
so does a PAC have to disclose all of its donors?
Isn't that, you report receipts and expenditures? I mean, that's what a
Yes.
PAC does.
Right.
It reports all of its donors
Yes,
and its expenditures.
yes. Organizations are different.
We need some help on this case, but Mr. Rubino, wasn't an issue that they didn't endorse or non-endorse any particular candidate? Wasn't that the key of the case? They didn't say vote for Joe, so they got away from, or they didn't say don't vote for Joe. If I remember, that was a piece of this.
Yeah, Mr. Chairman, so the ruling that just came down from the 10th Circuit, I'm happy to go through that. I mean, a good chunk of the opinion was whether or not the communication itself was an electioneering communication. And so it goes through whether or not it was an electioneering communication, whether it fit under any of the exemptions, such as the commentary exemption or, the protected by the First Amendment or the Wyoming Constitution. And so it does go through that. What was, so I mean, if that answers your question, but yes.
It gets
does
at
go
it,
in.
yeah.
Yeah.
So they were dancing in this area by saying our law is vague. You can't, it didn't pin down adequately what is and isn't restricted in the law. And it wasn't a vote for Joe ad.
The Wyoming gun owners, Mr. Chairman,
Yes.
the 10th Circuit's holding in Wyoming gun owners, it did deal with that. Tangentially, that was one of the claims by Wyoming gun owners. There was other language within that statute, specifically the relate to language, disclosing your donors specifically for an organization that it found unconstitutional as vague and not narrowly tailored as applied to Wyoming gun owners.
So would the activity of WIGO fall under this new definition of organization? Because they would definitely meet the definition of 2 or more persons, I'm assuming. And would the election communications or independent expenditures capture them?
Yeah, that was a separate, that's a separate issue. Whether or not they were an organization, they already fell under that ambit. So that wasn't being challenged.
Right,
Whether
but
or
under,
not they
but I'm
were
just,
an organization.
I'm trying to compare it to this new potential statute. This new potential statute would require them to disclose all their members.
Well,
And that, isn't that, I mean, now I'm concerned that that's a constitutional issue with the new statute.
I mean,
Mr.
this
Chair.
area of law, there, as the secretary had mentioned,
It's fluid.
there is some proceed with caution, I think, lessons from that. What I would say is, as it applies to the holding by the 10th Circuit and Wyoming gun owners and the disclosure of donors for an organization, what they found unconstitutional was the relate to language, whether or not it was the donations that related to the electioneering communication, whether that was overbroad and unconstitutional. And ultimately, the 10th Circuit held that it was unconstitutional as applied to Wyoming gun owners. So it's slightly different, I think, than the question that you're asking, which I think first was whether that type of organization would fall within this purview under the definition of organization. Well, it already did. The question was whether or not it had to disclose its donors for that, that had donated to that, related to that electioneering communication or not. And that related to language is what was just found unconstitutional as applied to Wyoming gun owners.
Josh?
Yeah, Mr. Chairman, and just to follow along with that, so just to clarify, so there's already this existing definition of organization. That's where the Wyoming gun owners were. This bill would expand that definition for groups that don't fall under the current definition of organization. And for those groups, it would allow them to not file if they had disclosed their members. So basically, that the disclosure of members wouldn't apply to a group like Wyoming gun owners. It'd just be for, we met at the coffee shop, we decide to spend money. We would meet this new definition of organization, but we've disclosed our names on the ad, and so now we don't have to file. That's the only intent of.
So you're saying that in the first half of the definition, a trade union, a professional association, a civic organization, whatever, they could have a political expenditure and not have to disclose their members? Only if they were just simply a group of two or more people, they would have to?
I think it's an independent expenditure.
So, Mr. Chairman, and that was what was at issue in that case, was they had to disclose those expenditures that relate to, or those people that, contributions that relate to that expenditure. And that's where the gun owner's case was, they didn't track specifically who donated money for what purpose. And so they didn't have that track to say, this person donated money for this expenditure. So that was a separate, that was what, my understanding at least, and I haven't done a full dive into that case. But anyway, this is a separate issue. It would expand that definition of who's an organization. And then through the existing statute, there are separate tracks, kind of political action committees are required to file and report things one way, and organizations are required to file and report things in kind of a different manner.
Mr. Chairman,
Mr. Co-Chairman?
in all these examples, we keep falling back on this coffee shop example where, four people around coffee and they decide to put $100 in a piece and do that. And that sort of minimizes the extent of what this could be. I mean, it isn't necessarily a coffee shop example. I mean, it could be an organization of any size, any number of members that maybe they would grow enough to get the attention of the county attorney, but we do have an enforcement problem, but we also have an education problem because these people didn't know. And when they go to the website and it says, do you have a treasurer? or it demands a treasurer and they don't have one, they don't think they fall into that.
Well, it won't, Mr. Chairman. It
Won't let them.
It won't let you continue, yeah.
Mr. Chairman, by statute, and I left my statute book back there. If you have a political action committee and you're required to report with the state of Wyoming, you are required to form it electronically. What I will say is that what we've set up with our campaign finance wizard is that it's supposed to provide sort of an easier way to do that rather than, this mishmash of spreadsheets or anything like that. The orderly ability to receive contributions and expenditures, that's sort of the impetus behind that.
And that's kind of the problem here is we keep saying we want this reporting and it's required by law, but we squeeze them through the reporting requirements established in a particular manner. And I get it, there's no other way to do it probably, but it doesn't convey to our citizens that they are required to do that, even if the reporting is what's required. It diminishes that. So my guess is that the bill doesn't do any harm, doesn't fix all the problems. I'm really worried that if we don't do something before this election, we could have a lot more infractions and a lot more lackadaisical. What county attorney wants to jump on this? That's the last thing they want to do, is get in the middle of a political fight in their county. They really don't.
Mr. Chairman.
Clerk Freeze.
Mr. Chairman, so one offshoot, if you didn't want to do this bill, I don't know that this would help. I've had a conversation with the newspaper who was fairly new in Fremont County. It could have been stopped there because the radio stations absolutely will stop you there. You don't get to say, I'm a citizen for green grass. You don't get to say that. They want you to say, I'm a PAC. They follow the federal reporting. But maybe the Press Association just needs to get a packet from Secretary of State's office that says, here's the new guidelines to the Press Association. And maybe we don't go this direction and we push for people to do what it says in the law. I mean, it doesn't hit absolutely everybody. I mean, all your printers in the state and all that, I don't know how well they did, but this particular instance was media.
Yeah, but Mr.
But I don't know
Chairman,
how many instances I don't know about, but.
nobody communicates elections via radio and print newspaper. It's Facebook, it's web, it's emails. It's all entities that don't have any clue. They're not in the media business traditionally. Like, they haven't been through a bunch of elections and no one's enforced the law in that area. Half the money I spent the last election was on Facebook. I don't think it works to just educate the printers. I didn't buy any newspaper ads the whole time.
Other questions for Ms. Freeze? All right, thank you.
Thanks for the conversation anyway. I appreciate it.
Yep, I don't know that we're necessarily getting anywhere, but we're trying.
Any other public testimony?
Other public testimony in the room?
Mr. Chairman,
Representative Ottman?
if I could, please. In this day, I'm old school, of course, but in this day of computers and things like that, you see if there's not a box to check, then it's got to be a problem. And sometimes there just isn't enough spaces or enough boxes to check. And so what Clerk Freese was saying about, okay, you didn't know that you had to do it, and then you tried to do it, and there was no box to check. So you have been given a warning, and you either group up or there's a penalty. Could there just be, something as simple as that? If you meet the criteria of a PAC, then you need to organize. And then that way, those people would know, yes, you do need officers. And if they're going to continue in these activities, then they need to formulate. But that would at least give the clerks the opportunity to educate those people or to tell them, this is the law. Because, I mean, honestly, until 3 years ago, nobody was doing stuff online, you know? And that's why we have the laws that we have, and things were handled. So since COVID and since so many things are online, we just need to just realize that there's some things that computer programs and computer checklists don't cover because we hadn't had to deal with it before. So all I'm saying, I guess, is that the clerks would have the opportunity, responsibility, and the authorization to handle what comes into their offices,
Well, they
whether it
did
be to
in-
go to the county attorney.
Well,
or
they did in the instance that we're aware of in Fremont County. The clerk testified that she told them, you have to have a PAC. I mean, the clerks did the right education. They sent them down the right path. And then this person was apparently confused about the process. And then
Yes,
ultimately the issue came down to a county attorney who interpreted the statute wrong.
yes. And Mr. Chairman, just to say then, I believe, and I could be wrong, but I think that this person is well aware of that. Then if they're going to do these activities again, they best,
At this
Get
point, I would hope
organized.
so.
yeah. So, so, okay, thank
But
you.
yeah, thank you, Representative Ottman. Ms. Simmons.
Gail Simmons, this time speaking as someone who has run up against this myself. So a couple of things. Mr. Chairman, not having a treasurer is really easy to fix. If you got 2 or more people, have one of them be the treasurer. I find that excuse to be rather it doesn't hold water.
Yeah, I'm going to try it on my candidate committee.
Yeah, there you go.
Sorry, I don't have a treasurer.
Exactly. So, and so I actually ran into this because in the last election, I was individually working on creating cards to send out in support of both myself for precinct woman, as well as a whole bunch of other people that I thought would be good precinct men and women. And so I was doing all that myself, and I already had them drafted up to say paid for by Gail Simmons, because my local printer will not do elections without a paid for by. Then I got a call from somebody who said, I need some information. I want to send some flyers out or some cards out to ask people to vote for me. And I said, well, you know, I'm already doing that. And he said, well, then let me give you some money. I said, okay. And then he said, well, let me let some other people know they can give you money as well. So here I am focused on the fact that I'm trying to get these cards out, and I've got the addresses, and I'm, you know, it was all my idea. It didn't even occur to me that I just crossed over into PAC territory. But because I did get money from more than just me, I felt it wasn't appropriate to say paid for by Gail Simmons. So I said paid for by candidates, because every single one of those cards had a candidate who'd given some money to it. So my bad, it was not clear. So when the complaint was made, I got a call, I on Facebook, somebody said, did you send this out? And I said, of course I did. It's the same thing I sent out last time. And so a complaint was made, and then that circled around to me, and they came, the elections office and the attorney said, yeah, this could be a problem. So I flat out asked, should I have created a PAC? And is it okay if I do one now and clean this up? And was told yes. So I went and got one of the people to sign up as one of the officers, got all the requirements done, said who had given me money, how much I had expended, filed that within the 10 days window that you have after an election, and then immediately canceled it. So I cleaned it up, but this idea that you don't have a treasurer, you don't have a chairman, that dog don't hunt. just go out and get one. So I think that this language does help clarify. I would also say that because you can do it manually in the county, and mine was just within the county, I could do it manually. I didn't have to run into the YSIT, the system at the Secretary of State. Again, if you're going to be expending money, get the organization set up. And then secondly, part of the problem in the Fremont case was just like the one that was up in the Northeast, where it covered three different, in that case, it was three different, right? It was a federal, a state, and a county. And in the Fremont, it was the state and the county. And so for future, you might look at saying, you need a separate pack at the different levels. But I would say this does no harm. And I think that the excuse of, I don't have the officers, well, then get some. If you're going to take the money and then expend it in advancing of this, get the officers.
So just, Mr. Chairman, it's interesting at the Save Wyoming rally, I believe congressional candidates were part of that. I don't know whether there was expenditures in support of that. So it could have had federal implications.
Mr. Chairman, the other interesting thing is that in the statute definitions of electioneering, it only counts 30 days before an election. By that time, half the people have voted and almost everybody's made up their mind. So when you do take a look at that 22-25, you know, the negative campaigning that has already started for next year is falling out of that people shouldn't get a pass for that. You can't address it now, but that is something to look at looking forward and redefining what electioneering is. If you're slamming somebody who is in an elected office, I don't care if it's in the election year or not, it's negative campaigning and ought to be subject to electioneering. Thank you.
Questions for Ms. Simmons? All right, thank you.
And just to summarize, it sounds like she says, this bill's okay, it does some good, there's more work to be done.
Other public testimony? Any public testimony online? Yep. Steve Klein. Mr. Klein, welcome.
Thank you, Mr. Chairman. Stephen Klein on behalf of Wyoming Liberty Group. It's been kind of in the rafters. This interim, of course, it's great to see some members of this committee. Many of you I've never had the pleasure of meeting in person. I've been away from Wyoming for some time, live in Washington, D.C., work here in a nationwide free speech law practice. Just yesterday, won a case in New Hampshire, over the summer, a case in Oregon. And I want to talk today at least a little bit about a case we just won in Wyoming, the Wyoming gun owners case. So on and against the bill, particularly what the attempt here is. First, I do have to say at the outset, and I actually have to thank the Secretary of State for pointing out what is, without saying it, there's an error in the memo that I submitted to the committee. There is, in fact, a definition of political committee or political action committee in Wyoming law. I've done this for 15 years and I can get lost in Wyoming statutes. And so nevertheless, that's an error, but it doesn't really go to this organizational bill. The outcome of the Wyoming gun owners case as it stands is that, and I can name the statute here, 22-25-106H, which I believe Senator Scott mentioned earlier, that is unconstitutional as far as the reporting requirements. The only reason there's an organizational definition or organizations as they currently exist in law or under this new bill, the only purpose of this bill is to get them to register with the state after they exist, and then for them to report. But the reporting requirements are unconstitutional. There's really nothing anybody has to report when they take out an independent expenditure or an electioneering communication. This is if they are an organization, mind you, not if they're a PAC. There's nothing it's unconstitutionally vague, and there's simply nothing that they have to report right now. Now, At best, people could say that this was an as-applied ruling. Some lawyers might say that Wyoming Gun Owners is the only organization that is exempt under this statute. I hope the Attorney General or Secretary of State would not take that position, because you're going to have a lot of organizations lining up at the federal courthouse for easy relief. More broadly, as I point out, even with now seeing and returning to the actual definition of PAC, it is flagrantly unconstitutional. I'm happy to discuss that. I know it's not specifically part of the bill. There are many, many myriad problems, other problems with Wyoming campaign finance law. I think the only thing I would add to my testimony is, in the more than an hour there's been discussions here, is a lot of y'all are saying the quiet part out loud. You're saying that these laws are geared toward making people polite, that you're really upset that people are being mean during the election cycle. And that is not a justification for campaign finance laws, period. This is supposed to be about corruption or its appearance, all right? And if you define corruption as being mean, well, forget campaign finance law. The Supreme Court has dismissed that for a long time. Mean speech is one of the very reasons we have the First Amendment. It's why the Alien and Sedition Act, particularly the sedition part, was such an anathema on American history. Corruption or its appearance really is limited to, okay, somebody's giving money to a candidate and I think they're unduly influenced. Or in the post-Citizens United era, somebody's taking out an advertisement and saying nice things or mean things about this candidate. That must mean that the money they're spending amounts to undue influence on that candidate. So we need this disclosure. Well, all right. And the problem is, fundamentally, that disclosure does not answer that question. It just raises more questions. I have no idea and I've done it for 15 years, and I think it's the silliest area of the law. I think it serves absolutely no purpose, in particular because we've raised that question. And I could go into why CFIUS right now, and I could see some organization that gave to some candidate. I could ask you point blank right now, are you in that person's pocket? Are you in that organization or PAC's pocket? The answer is going to be no, and it's probably true. But the disclosure itself didn't answer any of that, right? And it's going to feed. You speak of politeness and being, mean. It's going to feed on that kind of sentiment that everybody's bought and paid for. Well, if you're the one on the committee, you're looking around going, well, I'm not bought and paid for, but my opponent is. Well, you're part of the problem. If you can look at yourself honestly and say you're unduly influenced by money and politics, then do the best thing and resign. Get out of office. So that's my soapbox version. But for the purposes of this bill, it is another unconstitutional addition. You can't have an organization exist just to register with the government because it exists in order to not fill out reporting requirements because they're unconstitutional. So if this were enacted without significant amendments to Part H of the reporting requirements, it's just another easy lawsuit. So I'm happy to sit for questions.
Questions for Mr. Klein? All right. Thank you, Mr. Klein, for joining us. Additional public testimony in the room or online? No? We'll close public testimony. Committee, what is your pleasure? Moved by Senator Case and seconded by Representative Yen. Senator Case.
Mr. Chairman, if Mr. Klein is correct, then we shouldn't have any campaign reporting whatsoever. For anybody, for anything, by any entity. Maybe that's the right way to go. But we've got this torturous deal where some people have to comply, and apparently other people kind of can skate around it. And there is a problem with the prosecutors, Mr. Chairman. This is the last thing they want to do. They just have no desire to do this. It seems to me that if we want disclosure, if you think disclosure is a good idea, you should support this bill. If you want to go down the route that Mr. Klein and says it's all unconstitutional, the courts haven't ruled that yet. They did rule in the Wygo case, and I don't understand all the pieces of it, but there were nuances about separate from all campaign reporting. If you just want to carry it all the way, why would candidates have to report? Get rid of reporting. Don't care how you spent the money, where the money came from, or your election. That's not where the law is right now. This was a pretty egregious violation of the law. And I'm not accepting the fact completely that it was innocent and had to do with the fact that the computer screen was, when we have the Wyoming Republican Party involved in the Save Wyoming rally and promoting certain candidates over others in a primary, you have the chairman of the party there, you have national precinct people there promoting Republican primary candidates, some above others. That's a violation of our law about the neutrality of a political party before the primary election. So I don't buy that this is some kind of innocent blunder. I think it was more organized than that. You can vote for the bill or not, that's okay. But I think we should try to move this bill forward.
Other discussion on this bill, Representative Yin?
Mr. Chairman, thank you. I do think during this discussion, we have identified a large loophole. So the question is, for me, if you are one person, can I, let's use an example. Can I, as the minority floor leader, go around, ask a bunch of rich people for money, take their money, and then make expenditures and not have to report any of that? And from my understanding on the definition of political action committee and the definition of organization, right now, I think the answer is yes. I think I could do that and not have to report any of it. Do we want that to be a different standard than the standard that we have for political action committees or the standard that we have for organizations? I don't think that they should be different standards, and which is why I seconded it. I think the easiest solution, frankly, is to change this to have the definition of political action committee just be one or more persons rather than two or more persons. And with that, I think I will call for that amendment. I'll make the motion to change this bill to be just amending the definition of political action committee to one or more persons. If there's a second.
Is there a second?
Did you just make the amendment?
Yeah. You made the Barlow amendment.
Barlow should second it.
I think,
Does that work?
I think it works. I think that's the crux of the issue, is that in the Fremont scenario and the scenario that Representative Yin just painted, the person thinks that they're not organized or associated with other people. They're just collecting their money. If you change the PAC definition to one or more persons, you capture that scenario. There's no way they're not a PAC. I mean, I still think that when one person starts collecting and raising money from 5 other people, I feel like they've associated with them. I feel like they're already there, but I think you can make it clearer.
Then let's second it.
Okay. Or did you have something, Mr. Secretary?
Mr. Chairman, could I? Thank you.
On
I
the-
just
are-
want
are you-
to.
Are you on the amendment?
Yes.
Okay.
I just want to alert you to 2225-101B, which states that the chairman and treasurer of a committee shall be separate individuals. And I do think, while we didn't anticipate this going in this direction, I think there are some implications with this amendment. Not prepared to speak to them, but yes, I at the very least, we wanted to bring that to your attention.
What was, once again, 2225-101B? Is that what you
The
said?
sentence 4, I believe. 1, 2,
101B.
3. Sentence 3.
Yeah, it says the chairman and the treasurer of a committee shall be separate individuals. So that's gonna be hard with one. Bipolar maybe, or dual personality. That sort of seems burdensome. So
Yeah.
even if one person's making the expenditure, they have to find somebody else to be one of the officers. It's sort of what happens in corporations, but we want it to be like that for free speech, for exercising your free speech.
Mr. Chairman, I think we had one more statute we wanted to bring to, that
Okay.
council had noted to bring to your attention.
Mr. Chairman, 22-25-106, subsection C. All reports required by subsection B of this section shall be signed by both the chairman and the treasurer.
Okay. This discussion is probably what our county attorney went down. And remember, go back to the original bill. What the original bill said, even if you don't form a PAC, you still have to report. What's wrong with having that as be our stopgap, taking this up in the interim to figure this out?
What was that? Even if you don't form a PAC, you're still a PAC.
You still have to report.
You still have to report.
And that gets around the cumbersome two individuals and all that. Josh has got his
So,
hand up.
Mr. Chairman, just to follow along with that, so then in subsection C, 22-25-101C, that's the part that applies to organizations. And that says that the filing shall include the name and mailing address of the chairman and treasurer, if applicable, or the organization's designee. So it could, so an organization could potentially be one person under the current way this is set up.
Forgive me, but I was the second on the amendment, but I don't think the amendment works.
Mr. Chairman, I'll withdraw the amendment.
No objection.
However, Mr. Chairman, if I may,
Representative Yin?
I do think we need a vehicle for this because after identifying a large loophole, it will be exploited if we do not do anything about it.
Any other discussion on the bill? Back on the bill, no one has not amended it.
It's obviously not perfect, and our campaign law needs a lot of work. But this does fix something that was a problem last time. And, you know, we're going to learn a lot more over the next election cycle. It'll be unbelievable. And we should, the first interim is when we should address that.
Any other discussion? Any other amendments? Sensing you are ready to vote, please do a roll call vote on 24 LSO 0099 campaign reporting.
Roll call, Mr. Chairman. Senator Barlow. Senator Boner.
Aye.
Senator Landon excused. Senator Scott.
No,
Representative Chadwick. Representative Haroldson.
No.
Representative Harshman.
Is he online? Excused.
Representative Knapp.
No.
Representative Newsom. Representative Ottman. Representative Wiley. Representative Yin.
Aye.
Co-Chairman Case.
Aye.
Co-Chairman Olson.
Aye.
8 aye, 4 no, 2 excused.
All right. Move that one forward. We'll decide later where it starts. Send her to the house. Let's take a break. Let's take a 10-minute break and be back at 3:15. And we're live and we're back. Next bill for our consideration is 24 LSO 0233, election offenses intimidation. Mr. Plum.
Mr. Chairman. Luke Plum, LSO. Yes, this is election offenses intimidation. What this bill does is it creates a new misdemeanor offense of election intimidation. Currently in Wyoming statute, there is the felony offense of intimidation in the election code. And so this one breaks it up between a misdemeanor, which would be the use of threats to try and influence or induce or attempt to induce fear in an election official, an elector, by use of verbal threats or from soliciting the contribution of funds for election assistance by those use of verbal threats or through any form of economic or official retaliation. And then, and this is on the top of page 2. This is creating the misdemeanor offense. And all this language is almost exactly the same as it is for the felony offense. It's just, this one is breaking it out to be more use of threats, while the amended felony offense is when there's actual violence, when a threat is actually carried out for this purpose. And so within the misdemeanor one that is created, there is a defense. It's basically to say that, even if you threaten someone, but you can't actually carry it out, it's not a defense to the prosecution if that's the case. So it's creating that new misdemeanor. And so then continuing through the bill, there's just there's a conforming amendment on page 3, but then, the felony offense generally is being amended, and it's now been changed to aggravated election intimidation to try and set apart it from the election intimidation misdemeanor. And this one really, the defining difference is if you induce or attempt to induce fear in an election official or an elector by use of force, violence, harm, or loss, with the intent to impede or prevent the free exercise of the elected, of elections, essentially. And similarly, if you're trying to solicit the contribution of funds or to help, with any type of election-related action, and you use physical violence to try and get what you want, then that would be part of the felony. A felony crime under the election code it all falls under the umbrella of Wyoming statute 22-26-101, and it's a maximum of 5 years imprisonment, a fine of not more than $10,000 or both, as opposed to a misdemeanor under the umbrella of Wyoming statute 22-26-112, which is up to 6 months imprisonment, a fine of $1,000 or both. And so those two, it's really that question of if there was actual violence carried out is what raises it to a felony. Intimidation would be a crime, if you're going to threaten someone or if you're actually going to carry out a threat in that case. And on page 5, this act is effective July 1st, 2024. I did include a staff comment on page 5 to show, because it does say that there's a small section that's repealed. It's that defense language that is now included in the new misdemeanor. It was removed from the felony provisions just because if you actually carry out your threat, it wouldn't be there. So that's just the point of that staff comment. But I think with that covers the bill, and be happy to stand for any questions.
Questions for Mr. Plum? Representative Ottman.
Thank you, Mr. Chairman. Lucas, I just have one question. Has there been, and if there has been, incidents of this in the state? Thank you.
Mr. Chairman.
Mr. Plum?
Representative Ottman, I did not look into that. If there was any specific reported cases, I'm not sure to look into, but I don't have that. I don't have any information if there have been prosecutions under the intimidation statute in the last, Good question.
Senator Scott.
Mr. Chairman, couple questions on page 4. On line 10, we've removed the economic retaliation. should we also remove the harm or loss as being just plain a little too vague for this kind of felony statute and just limit it to induce uh, fear by threat, by force or violence. And then down on line on lines 20 and 21, should we retain the official retaliation? Because it seems to me that where you're, and I take that to mean governmental retaliation, where you're using the power of the government to coerce behavior, that is particularly odious and ought to be a felony. So I'd like to get LSO's comments on those two issues.
Mr. Plum?
Mr. Chairman, the harm or loss language, I mean, I think this is making a fair point. I don't know if I really have a great answer to that question. You know, it's, yeah, by use of force, violence, harm, or loss. Just I think that's somewhat separate from the language that's used. I guess it is the similar language that's used in the misdemeanor, where it's use of verbal threats of force, violence, harm, or loss. And so just if there was, I think there was just that thought of consistency between the two statutes using that same language, just saying actual application of force, violence, or harm, or the threat of. And so that would really be a determination for the committee. And I think that's the same thing with official retaliation. It may, you know, it was removed from the felony provision just because the thought there was of actual force as, you know, actual use of physical violence as opposed to a threat or to some other, you know, necessarily official retaliation. I think the committee would like to maintain that as a felony offense. If you use any form of economic retaliation, just would recommend, yeah, removing it from the misdemeanor, because I think those would be functionally the same. And then it would have to be a determination of whether you prosecute it as a misdemeanor or a felony.
Thank you. Mr. Chairman, members of the committee, my name's Andy Craig. I'm the Director of Election Policy at the Joseph H. Rainey Center. I'm also an advisor to the Legislative Leadership Campaign Committee, LCC. And I just wanted to emphasize, I deal with election administrators across the country in Wyoming and elsewhere, and this is the #1 issue I hear about in recent years. They have been getting bombarded with harassment and threats. And a lot of it is that it's these borderline cases that prosecutors, including at the federal level, don't feel merit a felony charge, but the volume of them creates a real problem. And so having this option for the misdemeanor, I think would be an important addition. And it also lets the local prosecutors really make the judgment call of when something crosses that line. Because it can be a little bit subjective. A lot of these are people mouthing off in ways that are not very well considered, but the cumulative effect is real. So I think it would send an important message that this is something the legislature takes seriously and intends to be prosecuted and punished, because it should be. It gets to the core purpose of government and how important it is for our election administration. Nobody should have to deal with the fear of these sorts of threats. So I just wanted to make that point and answer any questions.
Questions, committee? All right, thank you for your,
Thank you.
Oh, Mr. Craig,
Yes.
thanks for coming out and testifying on this. So my thinking before was that because it's a felony in Wyoming, it's pretty hard to get a prosecutor to look at that. So there wouldn't be likely, it'd be pretty unusual circumstance for a prosecutor to think that it warrants picking it up. But that if it's a misdemeanor, that gives them an option where something, they don't want to charge somebody with a felony, but they want to send a message. It gives them that option, and that wouldn't have been there before. Otherwise, it's just a hammer. Now we've got I don't know, look for a tool in the middle, maybe a screwdriver or a little tap hammer instead of a sledgehammer. But is that kind of what your point is?
Absolutely. I mean, a lot of these cases are going to need to be scared straight, and it works. You have somebody that shows up at the polling place and gets belligerent with a poll worker. And, no prosecutor is going to look at that and say, this somebody needs to go to prison for years. But an effective slap on the wrist, or something maybe a little bit more severe than a slap on the wrist, but having the misdemeanor option, I think would be important. And regarding the question of how many prosecutions there's been, that's why there haven't been prosecutions. But I think you will absolutely hear from people that these kinds of things happen. They just don't rise to the felony level.
Thank you so much.
Thank you for your testimony.
Thank you.
Additional public comment about in the virtual world? No public comment online. Closing public comment. Committee, what is your pleasure?
Pass.
Moved, do pass by Senator Case, seconded by Senator Barlow. Any discussion or amendments on this bill? Any amendments?
Senator Scott has his hand.
Oh, Senator Scott.
Mr. Chairman, in the felony provision on page 4, line 10, move we insert the word "or" before violence at the start of the line, and then move we delete the words "harm" or "loss." I'm just trying to tighten the felony up so that it really involves use of force or violence.
Seconded by Senator Barlow. Everyone understand the amendment? Any discussion on this amendment?
Discussion, Mr. Chairman?
Yes, Senator Case.
And I'm just asking questions of the members. Can you think of some kind of intimidation that rises to a very high level that doesn't involve force or violence? I mean, that's physical force or violence. I'm really just asking the question. Loss of your job might be one. It could
Mr.
involve
Chairman,
real estate, it could involve, it'd be economic kind of consequences, but do we want all those economic consequences to be misdemeanor or not? And I'm okay either way on this, I think. I'm just asking the question.
Senator Scott?
Mr. Chairman, my answer to that question is that I think the economic ones belong in the misdemeanor category.
Even if they're astounding?
Yeah,
I
also
mean,
your
I mean,
job is pretty
and
astounding.
Senator Scott, Mr. Chairman, in terms of the theft statute, consequences of $1,000, I think is a felony versus, I could think of economic consequences involving much more than that would, in this area, that would be misdemeanors now. So I don't know, and it doesn't seem comparable.
Any other discussion on the amendment? You want to repeat it? The amendment is on page 4, line 10, after the word force, insert "or," and then on line 11, strike "harm or loss." So that it would read "of force or violence." Everyone understand the amendment?
Call for the question.
Question on the amendment? All those in favor signify by saying aye.
Aye.
Okay, all those opposed?
No.
That amendment has failed. Are there other amendments to this bill?
And Mr. Chairman, there is room in there if people want to think about it for a dollar limit of some sort or a dollar connection, but I don't have the wherewithal to do that. I think the prosecutor's going to think about that, whether they bring the misdemeanor
Yeah.
charge or the felony charge.
I think you're right. Senator Scott, sorry.
Mr. Chairman, on page 2, on line 4, it says, or any form of economic retaliation. Mr. Chairman, the concern I have there is, I think that what you will see is citizens get annoyed with somebody, they'll threaten to say, I'm not going to do business with you anymore if you're going to do that or support that. And do we really want to make that criminal, or is that going one step too far?
So
Senator
I've
Case?
definitely, Mr. Chairman, I've had people that took their business elsewhere because of my politics. And I don't want to go after them. Senator Scott's right on this. I don't know if there's if the word. Some of economic retaliation is free speech, so they got to figure it out here.
Senator Boner?
I mean, Mr. Chairman, it's my understanding this is in the context of the process of voting. It's not at any point, and we're,
Right,
for any
that's
sort of
actually-
political position. I mean, I think we've all heard stories of, and I know one of our former Senate colleagues used to do a lot of, business with a school district, and they decided they weren't going to do business with him anymore because of the way he voted. I think that's well outside the intent of this bill. This is specific, it's my understanding, to the process of voting, an elector going to the polls and casting their vote. And so I think we're covered from people taking their business elsewhere because you disagree with somebody's politics, whether
There
it
you
be
go.
elected official or otherwise.
Yeah, and Senator Boner, you're right. It's getting late in the day and I apologize. Mr. Chairman, Senator Boner it is inducing or attempting to induce fear in an election official or elector by this action, including the economic retaliation. So it's like telling your neighbor that, or telling your employees that they'll lose their job potentially. That's a big one, but if they don't vote the way you want them to vote. Getting tired. I don't know. I haven't heard from him.
Senator Scott, did you have something? No?
Anything else on the bill?
Anything else on the bill? Any other amendments on the bill? Discussion on the bill?
Question.
Let's do a roll call vote on 24 LSO 0233, election offenses, intimidation.
Senator Barlow? Senator Boner? Senator Landon, excused. Senator Scott?
Aye.
Representative Chadwick? Representative Harrelton?
Aye.
Representative Harshman, excused. Representative Knapp?
Aye.
Representative Newsom? Representative Ottman?
Aye.
Representative Wiley? Representative Yin?
Aye.
Co-Chairman Case?
Aye.
Co-Chairman Olson?
Aye.
12 aye, 2 excused.
Gaining as we get through.
All right, as we get further into the agenda, we become unanimous and tired. Imagine that. All right, 24 LSO 0277, electioneering too close to a polling place. Mr. Anderson.
And Mr. Chairman, just while we're setting this up, there's been a court case since we did this one as well. So this whole bill may be moot by the time we get through it, but it is noticed for the public. So let's have the discussion. So,
Yep.
okay.
Mr. Anderson.
Yes, sir, Mr. Chairman, Josh Anderson, LSO.
Is your mic on, Josh?
Yeah, sorry, Mr. Chairman, Josh Anderson, LSO. So yeah, this was requested at the end of our September meeting, which, as you remember, was mostly dedicated to the electricity rate issues that we'll be discussing tomorrow. But this was a bill request that was in response to a federal district court decision related to electioneering too close to a polling place. Since the time this has been requested, the 10th Circuit just released an opinion overturning that lower court case. So what this bill does currently is just changes the distance that electioneering is prohibited on the day of an election from 100 yards to 100 feet. Again, and then the 10th Circuit case indicated that the 100 yards was acceptable under the Constitution. I'd take any questions, Mr. Chairman.
Questions for Mr. Anderson? While you're there, the court case, can you summarize the court case for us?
Sure. So, Mr. Chairman, the lower court case.
It was a Wyoming case.
Correct, Mr. Chairman. It said that the 100 yards was arbitrary and suggested that it could be it was too broad and that 100 feet would be better. The 10th Circuit overturned that, said that the 100 yards, 100-yard distance was acceptable under the Constitution, and it did call into question, as you see further, there's 100 feet on all other days under our current statute. The 10th Circuit case did call that into question, but remanded that to the lower court for further action, so that piece hasn't been decided yet.
And Mr. Chairman?
Yes.
Was this a case that originated in Albany County? That's not the case. It was in Laramie County. And so I remember a similar case in Albany County where they had the distance from the courthouse, which was the polling place, and it encompassed private property within the ring of that distance. And that was the case in Albany County. But was it a similar situation in Laramie County, or does anybody know?
Mr. Anderson, do you know?
I don't know the specifics, Mr. Chairman. I haven't dug into the case too deeply. It just came out the other day, but the clerks may have more info on that.
They could be next.
All right. Thank you, Mr.
Or the
Anderson.
Secretary of State.
Secretary of State's office, do you have any comments on this? Okay, clerks.
Here they come.
You got fired.
Good afternoon, Mr. Chairman and committee, Mr. Chairman's and committee. I'm Mary Langford, and I have the honor of representing the county clerks of the state of Wyoming. With me this afternoon, I have the Honorable Julie Freeze, Fremont County Clerk, and the Honorable Deborah Lee from Laramie County, and she can speak to this. But prior to that, just for a second, in our President Malcolm Irvin's stead, he wanted to make sure that I thanked you for, in the 11th hour, having this bill drafted and bringing it for no apparent reason. So, so thank you for that. And I'll hand over to Deborah.
Clerk Lee.
Mr. Chairman, thank you. There was a question about what this lawsuit was originally about. And there was a new resident to Wyoming, and he wished to campaign outside polling places and be a proponent for Second Amendment rights and other issues. And he felt that Wyoming's law was very restrictive and it prevented him from doing what he wanted to do. So therefore, he brought this suit. Even though, he hadn't been denied, but he said our laws prevented him from doing, exercising his free speech. So Mr. Klein from the Liberty Group was representing him in this case. The lawsuit, as I recall, was filed in July 2020, so it was before the primary. And the Judge Friedenthal issued her order in July 2021. And Laramie County filed our notice of appeal for this case August 2021. So we've been waiting all this time for a ruling. And to quote Senator Case, we are on the eve of an election and the county clerks were getting a little bit concerned that going into the 2024 election, we had no law that was, enforceable going into an election for election day. So that's why we had requested this, the legislature consider this. And then coincidentally, on October 23, the 10th Circuit came down with their ruling stating that Wyoming's law buffer zone is reasonable and does not significantly impinge on constitutionally protected rights. That is the election day buffer zone.
Senator Case.
Thank you. And Clerk Lee, thank you very much for that. And I really appreciate it. The difference between, it's 100 yards on election days, primary, general, and whatever the special or whatever, but it's 100 feet otherwise. But yet we have, most courthouses are polling places for the whole period of early voting, right? So during that period, the 100 yards applies, right? Or does the 100 feet apply?
Mr. Chairman, Senator Case. So during early voting, it's 100 feet.
Yeah. In the end, despite the fact that we won on this case, does it make sense to make the law consistent? And is 100 feet such a bad idea? And to be consistent with the early voting period?
Getting some nods.
Because I'm really not grasping that. And I agree, we don't have to do this. There's no urgency. On the other hand, 100 feet actually sounds better to me. So I'm asking.
Mr. Chairman.
Or Clerk Lee.
Senator Case, for those of us who are in the trenches on election day, there's a lot of activity. And I will say that in 2022, we had a lot of problems with petitioners, petition circulators who were extremely aggressive with voters and getting very, very close to polling places because they're paid by signature. So they have an interest in getting as many signatures as they can, and they have a deadline. So they were very, very aggressive, impeding voters as they were approaching the polling places, misleading voters. We had a number of physical altercations. As well, in 2022, my office received a number of calls from both voters and candidates who were complaining about very aggressive campaigning in front of polling places. And one woman who, her call to me impacted me greatly. She said, I've been voting for decades. She was in her 70s. And she said, I'm telling you, when I went to vote today, I felt like I was crossing a Union picket line. There were so many candidates and their supporters that she said, I could hardly make my way to go and exercise my right to vote. So that's what I would say on that.
Clerk Freeze.
Julie Freeze, Fremont County Clerk. So I would echo what Deborah Lee had said. I know 2 years ago when we had no buffer zone, and I talked to poll watchers in my area, and I talked to party chairs, and I talked about where I would be able to stop people from literally following them clear to the ballot box, you know, to, where do you stop that? And they were very, very supportive of, we don't want them in the building. We support you. And I said, I don't have that ability. So in our county, I mean, bipartisan, you know, not wanting to make the voters feel like they don't want to go anymore. We don't want to do that. And the only reason we asked you is because of what I just said. I didn't know where to stop them. And some county attorneys were going, well, you could do the 100 feet. And some county attorneys were saying you couldn't do the 100 feet. So it wasn't uniform. And so I think that's really important that we just get back to what it was. I think that's where people were the most comfortable, and it's not that far away. Senator Cashew knows well at the Lander Valley High School Fieldhouse. It's in the middle of the parking lot. Basically, and there was people up and down the roads waving at people. I mean, they still were able to do that. But when you got to go in to vote as a voter, you didn't feel like you were being attacked, watched, bothered for all kinds of things. So I think it's really important if we just leave it back to the 100 yards, which people were really used to and really missed. We got a lot of complaints about do something about this, and we couldn't. So they're very well aware. I believe it was back to 1973 that this law has been into place at 100 yards. So we would like to just keep it at 100 yards and work with it that way if we could.
So what about, in terms of the question of consistency, what about making it 100 yards year round?
Mr. Chairman, so it used to be that way at, you know, from our polling places at the courthouses. And then we did infringe on those people who lived by the courthouse because it's too far away. So the 100 feet kind of kept it to most parking lots for your courthouses where you were doing early voting. So we were not imposing on the rights of the people that live next door, I believe, is the way I believe that worked out.
If you run into private property, they can't have a sign in their yard.
Right. So the 100 feet has also been working for the short time that has been that way. So again, it gives you some buffer zone for the people coming into the courthouse, but far enough away that you're not impinging on a lot of people having to see campaign stuff. So.
And I guess, Mr. Chairman, if you do the math, the circumference of 100 feet radius is considerably smaller than the circumference of a 300-foot radius, which is what 100 yards is. So people turn out on the big days. I mean, it's a concentration of candidates and stuff in that perimeter. They're all, if you had a smaller perimeter on those days, it'd be pretty crazy, you know. Anyway, so that's the math. All right, maybe we're done with this bill.
Additional questions for the clerks?
Yeah, we do have to.
All right, thank you.
Thanks.
Additional public testimony online? Any public testimony in the room? All right, close public testimony. Oh, okay.
I kind of like the idea of tabling it. What do you think? Shows that it's safer than taking up and voting no. It just says it wasn't relevant. Sorry.
Mr. Klein, welcome back.
All right, thank you, Mr. Chairman. So Stephen Klein from Wyoming Liberty Group. So the Wyoming gun owners case was discussed earlier. That was a 10th Circuit decision, appellate court decision. And in that's over because my understanding is the Secretary of State and the Attorney General do not want to proceed further. The Frank versus Gray case, the case regarding polling place buffer zones, is also a 10th Circuit opinion, but there's a lot left to unpack. I chuckle about this case a little bit because it's definitely a case of speak of the devil. When we filed it on behalf of Mr. Frank and a signature gathering company called Grassfire LLC, you know, my sentiment was I was a lot more bullish about striking down absentee polling place buffer zones than necessarily the 100-yard zone on election day. And it's kind of again, the speak of the devil situation, you know, winning a limited win against the election day zone at the district court, going up on appeal and losing everything, admittedly, substantively. There's nothing wrong with the law right now, but it has been remanded for a more robust consideration of the absentee zones. I just want to counter the county clerks a little bit that, the factual record in this case, as a matter of policy, whether this is a First Amendment case or not, and I think it still is for a variety of reasons, but whether it is or not, we have sworn testimony in the record that county clerks or their staff are going onto private property that falls easily within that 100-yard election buffer zone on election day and pulling up yard signs. They're either warning property owners or they're pulling them up themselves when nobody's home. That's not about voter intimidation, all right? I go back when I think of the absentee zones in particular, and this is I'm a pretty patient guy, but my first problem with these absentee zones came about in 2014 when an independent candidate was gathering signatures for his run for governor, and he eventually successfully, but his signature gatherers ran into a lot of hassle around the Laramie County government complex. And I have a serious problem with that. You can, on one hand, often in a discussion of election polling places, and Burson versus Freeman, the Supreme Court case that upheld a 100-foot buffer zone back in the early 90s, kind of spoke to this, and I think election day buffer zones or election day polling places in Wyoming do reflect this. It's a dedicated place where people are coming together to vote. Government complex and courthouses are a lot different. And I have to chuckle about the Laramie County government complex. They put 5 voting booths in the atrium. It's the only polling place I've ever seen where you can buy yourself a sandwich at the snack bar on your way out. There's a lot more going on, county commission meetings, offices, prosecutor's office, I think public defenders in there maybe, but the county clerk herself is in there. So when you're talking about signature gatherers or the like, or even electioneering, you're reaching first-time voters. They have to go there in person to register to vote. So even from a policy perspective, wherever the Frank v. Gray case stands right now, I think it certainly behooves the committee to consider these amendments and certainly to have an understanding that the case is far from over. And I'm a very patient guy, and my understanding is Mr. John C. Frank is as well. And I'll sit for questions.
Any questions for Mr. Klein? All right. Thanks, Steve. Any additional public testimony? Nope. All right, close public testimony. Committee, what is your pleasure? Is there a motion to?
Well, I don't think the bill could die for lack of a motion. That would be one way.
Okay.
We could move it and vote aye or nay and kill it. We could table it. If we tabled it, I think the signal that tabling says is that we considered this bill and then we decided it didn't fit. And so we moved it. We didn't dig deep into it. It might be appropriate.
Senator Barlow.
Thank you, Mr. Chairman. So I'd move to table 24 LSO 234 indefinitely. Oh, no, 234, sorry. 277 indefinitely.
All right. The record reflect it's 277 that's being tabled.
It's non-debatable.
Who was the second? Seconded by Representative Newsom. All right. All those in favor signify by saying aye.
Aye.
Any opposed? That bill has been tabled. All right. We're not too far behind, but we are just a little bit behind. Special districts. We have 2 bills to consider under our special districts topic. The first is 24 LSO 0100, special district vacancies. Mr. Anderson. Walk us through this bill.
Yes, sir, Mr. Chairman. 24 LSO 100, working draft 0.4. This was discussed up at our August meeting in Douglas, and the committee determined to look at some revised language based on that bill. Senator Barlow took the lead on that, discussing with some of the interested parties. That's what's reflected in this bill. I don't know if they came to full final agreement on this language, but this was the most recent version. So this is, again, related to filling vacancies on special districts and when that term of office ends. So it would say an appointee to fill the office of a director shall serve until the office is filled following the next regular election. Term of office of an appointee shall not be extended in any manner beyond the term of office that the appointee was appointed to fill. If a vacancy exists following a regular election, the vacancy shall be filled as provided in subsection A of this section. So that's the bill as it stands right now, Mr. Chairman. I'd take any questions.
Questions for Mr. Anderson? All right, thank you, Mr. Anderson. Mr. Secretary? Senator Barlow.
Thank you, Mr. Chairman. So if the committee will recall at the Douglas meeting, there was kind of a back and forth on how to solve this. And I wouldn't say I facilitated a discussion, but I tried to facilitate a discussion between Mr. Rubino, Clerk Freeze, and Mr. Pepper, and to try to get our arms around something that got to the point. There were multiple versions. This is kind of the latest version that actually we had to make a couple technical suggestions to. So while this has been out there, this is not a consensus bill. This is one we thought we were getting hopefully closer to the right place. So I don't want anybody to be under the impression that the folks that are going to testify say this all checks all the boxes, because I don't know that we're there yet. I also remind you that I think this bill, and Mr. Rubino and the Secretary of State himself can speak to it, this came out of a request, well, it came from their office as a request out of a county attorney's office that was having a challenge with a particular district. So again, this is a bill to maybe try to fix one instance in one place that we're not sure ever repeats or should repeat, but we're still trying to get to what the right approach is. So with that, Mr. Chairman, certainly the experts are in the room. I was just trying to keep the flow going one way, and that was to Josh. This is what resulted. And if it's not what the parties think is meaningful, then we're back to where we were in Douglas. Thank you.
Secretary Gray.
Well, thank you, Mr. Chairman. For the record, I'm Chuck Gray, the Wyoming Secretary of State. To my left is Joe Rubino, our Policy Director and Counsel. I want to thank the committee for undertaking this bill draft, which we had originally brought in May concerning special district vacancies, specifically in that Wyoming statute does not currently prohibit special districts from unilaterally extending terms of appointments. The intent of the original proposal was to ensure that special districts would be prevented from doing so. Following the testimony from special districts and county clerks of the Joint Corporations Committee meeting in August, our office engaged with Senator Barlow, Clerk Freeze, and Mr. Pepper concerning slight revisions to the bill that would ensure uniform application across special districts, whether the term of appointment lasts to the remainder of the original term or until the next regular election. And I want to thank Senator Barlow and all participants, Clerk Freeze and Mr. Pepper, for engaging in that, and thanks Senator Barlow for spearheading that and really facilitating the communication. And I really do believe the proposed language in the current bill draft ensures the intent of the bill is achieved. The key section is the term of office of an appointee shall not be extended in any manner beyond the term of office that the appointee was appointed to fill. I do think if maybe you call it a concession, but the one, I don't think it's a concession, but the one clarification that I think this is on the special district side is the next sentence. If a vacancy exists following a regular election, the vacancy shall be filled as provided in subsection A of this section. And this gets to the point I've heard from county commissioners, which is that, well, nobody runs in the regular election. And so what do we do then? Is this prohibiting us from reappointing the previous person? No, I think then they would just appoint via that procedure in A, but it would allow an election to occur, which would allow the franchise and that process to be carried out. I'm gonna go ahead and turn it over to Mr. Rubino if he has anything to add, because he engaged in the communication on behalf of our office. So we had a couple different iterations there, but I think we got to the right point. And again, want to thank the entire a working group. Thank you.
Mr. Rubino?
Mr. Chairman, thank you. Joe Rubino. Yeah, I wanted to specifically point to the language that was ultimately reached, sort of the latest language. They're on page 2, line 14 on the web version, the handout. The term of office of an appointee shall not be extended in any manner beyond the term of office that the appointee was appointed to fill. So that was getting to that we encountered, and what we highlighted was in our discussions with Senator Barlow, Clerk Freese, and Mr. Pepper was that some principal acts of special districts, the term of appointment lasted until the next regular election. Others, it lasts until the remainder of the term plays out. So that the term that the appointee was appointed to fill is supposed to encapsulate all of that. That's all I have to add.
Questions for Mr. Rubino or Secretary Gray? All right.
I like the momentum.
Thank you both. Yep, we're making good time. Mr. Pepper? Clerks, I don't imagine you have anything on this one. Nope. Okay.
I like the momentum of this train.
Welcome, Mr. Pepper.
Thank you. Mark Pepper, Executive Director of the Wyoming Association of Rural Water Systems. I think we're really close. I like some of it, although I actually think in reading the corrective language in C that if you revert back to subsection A, it allows for appointments. So I don't think there's really any way that they can't reappoint the same person. I would have liked to have seen, and I still think regular election is up for debate as to defining regular election. I would like to have seen after the next regular election, in C, an appointee to the office of director shall serve until the office is filled following the next regular election for which the appointed member would stand for election. I think that defines what term they're going to be doing. The term of office of an appointee shall not be extended in any manner beyond the term of office that the appointee was appointed to fill. If a vacancy exists following a regular election and inserting for which the appointed member has filled, the vacancy shall be filled as provided in subsection A of this section, but cannot, inserting, but cannot be filled by reappointment of the previously appointed member. I think that probably, I think we're still, as Senator Barlow kind of said, we may be looking for a solution to a problem that really doesn't exist. I represent 200 plus special districts. I don't see this happen very often, that they just keep reappointing someone. Special district vacancies are a problem. We just can't get people to run for special district boards more than anything. So a lot of times it's the board is out there going door to door, trying to get somebody to serve. And he may decide he'll serve or she will serve for a period of time, but they're not going to run for reelection. No one runs for reelection or runs for the election. And 2-3 months go by and they go pound on the guy's door and say, would you serve again? And he'll say, well, I'll do it one more time, routine. I have some other thoughts on how we can do vacancies, but that would be a much longer conversation for another day. But that would be my suggestion would be, and I don't have the line numbers in there, but I would insert after the office is filled following the next regular election, insert for which the appointed member would stand for election. And then if a vacancy exists following a regular election for which the appointed member has filled. And then the last sentence, provided in subsection A of this section, inserting but cannot be filled by reappointment of the previously appointed member. And I'll stand for question.
Questions for Mr. Pepper? You don't have that in writing, do you? Did you circulate that to us by chance?
I sent it to Senator Barlow, probably has it in the strings. I sent it yesterday, or I sent it on the 12th to Mr. Rubino and Ms. Freeze and to Josh, as well as Senator Barlow.
Okay. Well, if someone does find it, you could forward it on to the committee, that'd be great. Any questions for Mr. Pepper?
Mr. Chairman.
Oh, Representative Haroldson.
Thank you, Mr. Chairman. So maybe not directly to you, Mr. Pepper, but if we could maybe pull up the Secretary of State's office again to have the conversation of their heart on that correction.
Okay. Don't go anywhere just yet, Mr. Pepper. We might, once we've got the amendment in front of us, we might have some questions for you. Senator Barlow.
So I think maybe I'm going to speak to this first because what I understood was there were appointments that were going through an election. So there were appointments that were being made. And instead of saying, you're appointed, there's going to be an election, either run for office or we're going to do another appointment if that remains open, that seat remains open, there were potentially, there was no effort to recruit candidates and the appointment was just ongoing. And so there was not, it was, the appointment was not set to the term of office or the next election because the term of office, there was no term of office because the appointee was appointed. So what we're trying to clarify is that, that's one thing. The second thing, and this is a policy discussion that Mr. Pepper brings out, and I think that, and I haven't found the email yet, I apologize, I am looking.
Looks like we
whether
got
you
it.
do not, whether you do want to prohibit the reappointment of somebody, that is a, in my view, a very different question about whether we want to prohibit someone that served well and now can no longer serve, and there is no one to put in that office. So anyway, so one I think is just maybe not a clarification of what I understood the purpose was. Two, there's a very different policy question and a prohibition about a reappointment, and I did not hear that as a concern. What I heard as a concern was, should they be actually going through an election process, and what does that mean? But thank you, Mr. Chairman, for that allowance to kind of at least explain what I came to this with as we had that discussion. So thank you.
Thank you, Senator Barlow. And committee, it has been circulated by email from Josh. So we've got it if you want to take a look at that. Mr. Secretary, do you have an opinion on this amendment?
Mr. Chairman, and Mr. Rubino, you can weigh in a second. I want to turn it over to you, but I guess there's three segments on this, and maybe I'm in legislator mode for a moment, and if it's not okay, I understand if the chairman, but I guess my question for Mr. Pepper would be, what's he trying to achieve? I think there's three segments here. I think the third one is, as Senator Barlow said, is a policy choice. I'm surprised that Mr. Pepper's bringing that because it appears to be the opposite of what I would think the special districts would want, which is the ability to reappoint. And the way I read it, it prohibits a reappointment if no one runs. Obviously, that's a policy decision, but I'm surprised that suggestion's being brought. The original intent, again, is just to prevent an extension of a term. Wading into this question of somebody not running is I think, another question. On the first two, I believe what he's searching for, what he's trying to get is clarity rather than a policy choice. I think it's clear either way. The first part, I think arguably is more clear. The second part, I don't think is needed, but I don't think really any of it with where we're at is The first two, I think it's clear the way it is, but I'm not, I appreciate him bringing it, but, and then the third one, I think is a policy choice that goes in the other direction, and I'm surprised it's being brought, if I understand it correctly. The first two, I think, are just clarifications, and I think it reads fine the way it is. That's my personal opinion. Do you agree with that? I think the first two segments are basically operably the same.
Mr. Chairman?
Mr. Rubino.
Yeah, thank you. Yeah, I would maybe just invite Mr. Pepper to go through the clarifications. I view the current language at where we're at without them as also sufficiently clear. The third one, I think, obviously, I'll let Mr. Pepper speak to it. Certainly the intent was behind it. It was irrespective of what a vacancy would look like after such an appointment was not filled. If it was filled, then there would be no issue. Obviously at an election or at the end of the term, but what we were grappling with was a term extension beyond what was provided for, and having that. So if we're going to bifurcate it into or split it into three parts, the third, I think it may be just a slight mismatch of what the intent of the bill is. Nothing was intended to eliminate a recurring member, whether they're good, bad, or indifferent, from getting that appointment if they've already been appointed previously.
And Mr. Chairman, my one concern on the first two segments is that talking with Attorney Barron up in Crook County where this happened, the intent of this was not, there was no bad intent from what happened in Crook County. It had to do, and there's actually a couple cases of this that are happening now, with aligning elections and having elections sort of fit where the board wanted it to fit. And that inadvertently led to an extension of a term. And I think the way it reads now, I think it goes the opposite direction. I like the way it reads originally. I really do. That's my opinion.
Final answer.
Yeah.
All right. Thank you, Mr. Secretary. Mr. Pepper, do you have anything extra to add? Help us understand the why behind your amendment?
Yeah, Mark Pepper, Executive Director, Wyoming Rural Water. I don't think the bill's necessary. I just don't see it happening as often as what's going on with people just getting appointed and never standing for election or whatnot. That was my understanding of the discussion, was that there were people that were being appointed and then they were standing for election and just continuing their appointments. So by inserting some of the wording, the way the Secretary of State and Senator Barlow, everyone had come to an original thought process and was sent out prior to my sending this, an appointee to the office of director shall serve until the office is filled following the next regular election. In earlier discussions, we were having a difficulty on regular election because of the staggered election laws, having terms staggered, as well as special districts have differing election dates than primaries or general elections of other offices. So I thought regular election was still kind of up in the air as to defining an irregular election for a special district. That's why I inserted for which the appointed member would stand or could stand for election. And then the second part was just continuing that on with a regular election for which the appointed member is filled. And I thought we were trying to get at the part of somebody getting appointed, never standing for election. So I put in that last piece, which I'm more than happy to take out, because I think the way it's written, the vacancy shall be filled as provided in subsection A. If you go back to subsection A, you just reappoint the people. So it's a circle, and I don't know that the bill's necessary at all. But if it is necessary for clarification, I think we need to clarify what regular election we're talking about for the appointed member. And that's what I attempted to do by my insertions. But I'd be more than happy to drop and just say the vacancy shall be filled as provided in subsection A as this section, period. The last line I don't have a problem with, but I thought we were trying to cure perennial reappointments.
Yeah, I struggle with the last part of your amendment because I don't think the idea was to stop perennial appointments. It was just to have, it was to sanctify the process that person went through, passed through the process of being reappointed. I think that was it.
Yeah, and Senator, or Chairman, Mr. Chairman, Representative Olson, I'm fine with dropping that
Okay.
last sentence.
All right. Other questions for Mr. Pepper? I asked you if it was your final answer.
Well,
You said yes.
I want to be clear
Okay.
on, now that we've kind of gotten the third segment, why, I want to be clear in our conversations with Attorney Barron of why I don't like the wording in the first two segments of Mr. Pepper's amendment, which I think it appears to suggest that the board can set the length of the term. And that's why I think it's worded for next regular election. That's the problem. That's what created the problem in Crook County. And having it as the next regular election, I think with that addition, especially the first addition, I think may actually inadvertently make the situation worse, because then the board can just define when the appointment comes up for election, and it could arguably be indefinitely. And so I think that's my concern with the first two segments.
Thank you for that clarification. Have additional public testimony in the room? Any public testimony online? No additional public testimony, then I will close public testimony. Committee. I have a motion on the bill. Moved by Representative Haroldson, seconded by Representative Knapp. It's about time. Any amendments on this bill? Amendments to page 1. Amendments to page 2. No amendments. Discussion on this bill? Representative Wiley, oh, hey, welcome.
Yeah, I'm here. I woke up from a nap. I really think the committee needs to consider the implications that could have to these special districts. I don't think we should overreach to the point to where we're going to deter folks from wanting to serve on these districts. We heard Mr. Pepper talk about a lot of the times they have to almost forcibly get people to participate in these districts. An example would be of a sewer district who wants to meet every month for an hour or 2 or 3 and talk about what rolls downhill. So I think we should be very cautious.
We do it every day.
Yeah. We should be very cautious about deterring people from serving on these boards.
Any additional discussion on this bill? All right, seeing none, we'll have a roll call vote on 24 LSO 0100 special district vacancies.
Mr. Chairman, roll call. Senator Barlow. Senator Boner. Senator Landon, excused. Senator Scott.
Aye.
Representative Chadwick. Representative Haroldson. Representative Harshman, excused. Representative Knapp. Representative Newsom. Representative Ottman.
Aye.
Representative Wiley. Representative Yin.
No.
Co-chairman Case.
No.
Co-chairman Olson.
Aye.
9 aye, 3 no, 2 excused.
I think you called that one right. This is very well could be a House bill. All right. 24 LSO 0234 Special Districts Bond Elections Exemption. And we have Mr. Plum this time.
Is this our last bill?
This is our last bill for the day.
Question.
Thank you, Mr. Secretary, for spending the day with us.
Mr. Chairman, Luke Plum, LSO, here to discuss Special District Bond Elections Exception. And so this bill is affecting primarily two types of districts, improvement and service districts, as well as water and sewer districts under Title 18 and Title 41. And what this bill does is it essentially does the same thing for both. The language basically requires that if a board in a district wants to, issue bonds pursuant to, to the act that creates the districts to provide funds for the acquisition, construction, improving or financing of improvements, or, for services for the benefit of the residents of the districts, that they would have to do so by submitting the question to the qualified voters or the taxpayers who are within that district to be approved. What this bill does is it creates a new section, subsection B, and kind of notwithstands that requirement if the board is going to execute some sort of agreement to repay or to basically to receive the funds and borrow those funds from the United States government, the state of Wyoming, or any subdivision agency or department of either the U.S. or the state of Wyoming. And if that is the case, when they go to get those bonds, it actually would not be considered a bond, and it should not require an election under this chapter. And then there's a couple conditions on that. It would be that repayment is to be made solely from the revenue generated by the improvement or the service with which the financed improvement or service is associated, and that the security for the loans or borrowed funds is restricted to a claim on those revenues generated from that proposed improvement or service. I inserted C, that was the language that was provided by Mr. Pepper. I did break it out. He had it in one paragraph, but yeah, that kind of breaks it out a little bit. And then also there's a newly created subsection C. This is something that kind of came up through review and was a discussion that I think may not actually work that well in terms, especially for districts at this time, just because within subsection B, it did say, it shall not be considered a bond. And so subsection C that says that no bond shall issue, but I'm not sure that would be correct because I think there are agencies or, especially from the United States government that still may say, well, actually, we're going to technically issue a bond, but under this agreement, it wouldn't be considered a bond for the purposes of the statute so that they don't have to hold an election. But it's essentially the same language for 4110-128. For the water or sewer district, same concepts to, say that if they're going to borrow money from the United States, the state of Wyoming, it shall not be considered a bond, shall not require an election under those conditions. And then it also includes the no bond shall issue, but once again, that may be incorrect. And then finally on the last page, page 6 of the bill, there's just an applicability section in section 2 saying that nothing in this act shall be construed to impair or affect any bond, note, or obligation issued or created before the effective date of this act. And then the bill itself would be effective on July 1st, 2024. With that, I would stand for any questions.
Representative Ottman.
Thank you, Mr. Chairman. In the case, we're saying there the board is able to borrow money, but we're not going to call it a bond, so they don't need an election, right? What if these boards are uncompliant and are disbanded? What happens then to the obligation?
Mr. Plum.
Mr. Chairman, Representative Ottman, that's a really good question. Considering that they would, that they still, I think that's especially like where maybe, subsection C was short-sighted to say, there probably still likely would be a security that would be going for the loan or borrowed funds. It would be on whatever they use that money for. And so there still is a claim that's connected to the money, right? Like to the borrowed funds. It would just be from, so even if the district were to disband, there would still be security on the revenues generated from the proposed improvement or service.
Representative Ottman, follow up?
Thank you, Mr. Chairman. So who would be in charge of all that? Who would take care of it if there is no, who would collect the funds? Who would disperse the funds? I guess I'm just wondering if there is no bond, what, are you going to rip out a sewer or rip out water or tell people they can't use it or?
Mr. Plum?
Mr. Chairman, Representative Ottman, that is a good question, right? And I think the point of this, right, is that it shall not be considered a bond, but I think technically a bond would still issue. And so, yeah, that would be the question. I think under the dissolution of the board, that would have to be something that's carried out through the dissolution of the board. I think that would be, and I don't know, so I don't want to go out too far on a limb because I don't know exactly the answer, but I mean, there would be a process to have the board dissolve, and then there would be claims on their assets.
And that dissolution process might look, it's going to look different for each entity because it's going to be in statute, right?
Mr. Chairman, yes, I believe so.
Representative Newsom.
Thank you, Mr. Chairman. I have a question on page 2, the end of that page, lines 21 through 23. Repayment is to be made solely from the revenues generated by the improvement or service. So what happens in the instance that there is maybe some grant funding available or donation available, and that money would not be able to be used for the retirement of the debt service?
Mr. Plum.
Yeah, Mr. Chairman, Representative Newsom, I know there's been some discussions. I've talked to Mr. Pepper. I think, yeah, there might be a good question to that. I think it would be a decision for the committee to consider whether, yeah, that would be overly limiting in terms of repayment.
Additional questions from Mr. Plum? All right, thank you.
Secretary of State's office, clerks.
Well, the clerks have all abandoned us. The Secretary of State has abandoned us. We have other public testimony? Mr. Pepper, yeah.
Again, Mark Pepper, Executive Director of the Wyoming Association of Rural Water Systems. And I have with me, go ahead.
Yes, there we go. I'm Rick Thompson with the firm of Hathaway and Coons here in Cheyenne, and I am a bond attorney.
So if I may, a couple of the questions that have come up and whatnot. Mr. Chairman, Representative Ottman, yes, there's already dissolution statutes on record, and anything like that would just revert to the current statutes. So this would not affect any of the statutes that are currently on in statute for dissolution.
Representative Ottman, sorry.
Just because I don't have the dissolution statute right here, would that cover it even though it is property and not bonds?
Correct. Mr. Chairman, Representative Ottman, yes, it's a debt instrument. We're not eliminating the debt instrument, just the requirement for a debt or bond election, similar to what municipalities share or enjoy today through 157102C, which is the language that I proposed and that LSO has split into separate paragraphs. I think 157102C is the municipal exemption, and just adding a new paragraph A to 4110-128 and a new paragraph B to 1812-120, including the same language as in 157102C, achieves what we're trying to do and doesn't change any of the dissolution requirements or anything else. The short answer for special districts dissolution, depending on if it's a dissolution for if a special district wanted to vote to dissolve itself in connection with a nearby community, a municipality, they can do that already under statute. If both boards vote to do all that kind of stuff. If a special district, and I don't want to bring a can of worms up, but if a special district is insolvent under current statute, it reverts to the county commissions. But there's nothing in statute that allows a county commission to operate a water and sewer district or an improvement and service district. But that's for another day.
All right. Did you have?
Yes, Mr.
more
Chairman, if
testimony
I
to add?
could, please.
Yeah, go ahead.
I'd like to testify very briefly as to why this amendment's needed, and then talk about the language to accomplish that. I was representing a town recently for the issuance of water revenue bonds to extend their water system to a new subdivision. And they had a commitment from the USDA Rural Development to buy the bonds, to buy the revenue bonds once they were issued on very favorable terms, low interest rates, long-term to make the payments low. So we issued those bonds under this statute, under the cities and towns statutes 157102, and we didn't have to have an election pursuant to subsection C that we've talked about. Shortly thereafter, I was contacted by a water and sewer district that was geographically very close to this town and wanted to do the same thing, extend a water supply system to a new subdivision. And they too had a letter from the USDA offering to buy their revenue bonds. So they contacted me to issue revenue bonds to do that. And as I began reviewing their authorization statutes, they didn't have the same statute that the city and towns have in the subsection C that allows them to do that without an election. I was surprised, and they were too, and I told them, you can't do this without an election. So they postponed, as far as I know, the financing in the project. And my comment to their council was, I think it's a simple legislative fix. I think all you have to do is take the language in subsection C for cities and towns and drop it in, that same exception, into the special district statutes, and you solve the problem. And I think at that point, they reached out to Mr. Pepper, and then he has taken the ball and run with it to get this fixed. And I know I saw an email, I think in the August committee hearing, he showed you that language and suggested that in the two places in the special district statutes that he referred to, that we just take that same language and drop it in there. The concern I have about the current language is in that subsection C, it says no bonds shall be issued in the event an agreement to repay borrowed funds is reached pursuant to subsection B of the section. The problem with that is, in some instances, in the case I spoke to you about, the federal government actually prefers to buy a revenue bond. So we issued revenue bonds. They're the purchaser of the bonds, and that's how they bring their money into the deal, is by buying the bonds and becoming the bondholder. So we wouldn't want that language. It would be counterproductive. And the language above in the two subparagraphs are attempting to rewrite what's in C, but it's worded differently. It creates some inconsistency between the two, and it also creates some limitations that could be problematic, because I'm not sure how, in the case I gave, for example, yes.
You're a very important visitor. Mr. Chairman, can we recognize the chairman of the Senate Appropriations Committee and former member of this committee, Senator Nethercott? Yay!
Now don't run away.
Speech.
Okay.
Thank you, Chair.
All right.
So picking up where I left off, I'm concerned about the revenues generated from the proposed improvement. If it's an improvement of part of the system, there'd be some question about whether you could pledge all the revenues from the system, because that's typically what's done. You pledge your revenues from the system to secure the bonds, and then if you need to issue bonds later, you can issue what they call parity bonds that are on equal footing with the original bonds, provided that you have the debt coverage ratio. So my recommendation would be to use the same language you have in 157102C in these two amendments. Thank you.
Mr. Chairman, if I may.
Mr. Pepper.
I'd like to echo, and I think that answers Representative Newsom's question as well. The proposed language would provide possibly a restriction that would be difficult for a special district, which is basically a water and sewer district in my case, or an improvement and service district, could be a road district or whatnot. If they got a bond or a debt for a certain amount of road replacement, it would be very difficult to then charge assessments or whatnot by segment and have the segment be tied to a particular loan. All the revenues of the district would be utilized for that. And that's what the 157102C does as well for municipalities. It's if the loan or bonds, and I because of the clawback provision of grants, I think grants are involved as well. If the revenues are used, user rates, basically, to secure that bond, there's no difference and as Rick said, you just look at the loan values and debt to equities to see if they can cover any additional loans down the road. But I would like to have 234 take out all of that and just insert 157102C as a new paragraph in 4110, 128, and then a new paragraph in 1812, 120. I think that gets us where we're at. And I'll reiterate what I said in August. Last February, SLIB passed 51 special district loans that were probably without an election. So it's happening. We just need to legalize it.
All right. Questions for Mr. Pepper or his attorney?
A friend.
Mr. Knapp or Representative Knapp?
Mr. Chairman, thank you. Mr. Pepper, so I'm trying to wrap my head around this without any trepidation, I would say. Being a former county commissioner, special districts occur typically when they don't want city water or they don't want to hook on to a county sewer line so we've granted these districts taxing authority to accomplish these improvements, whether it's a road, whether it's sewer, whether it's water. So that taxing authority then goes to the residents that are involved. And that is why there's a vote taking place in the first place to say, you know what, we don't want to do this. We want to do it our way because we're rural or we're whatever the case may be. So they're allowed this taxing authority. Are you concerned at all that the revenues to pay back the loans, the bonds, come from the people that didn't have a say in what was going to take place, and that ultimately what will happen is you'll either have compliance or you'll have defaults, but ultimately counties and or cities will be the ones picking up the tab. And if all it's based on is revenue from those citizens or those residents, you're going to have some troubles if you have defaults. Would you agree?
Mr. Pepper?
Mr. Chairman, Representative Knapp, it depends. I'll put it that way. So yeah, you're right. Special districts typically are formed primarily because they're too far out from a municipality. And the municipality does not want to extend service or does not want to extend their boundaries and annex or whatnot. The revenue structure, it's still in this case, the state or the federal government is going to look and make sure that it's viable. We passed an exemption many moons ago that exempted utility rates for governmental units from Public Service Commission hearings, except for privately owned water and sewer water systems, of which there's 11 in the state. But those revenues, and to your point about the election, yes, they do have taxing authority. Not as many exercise that as you would like. It does have to go to a vote of the people. Most of them vote it down. So it comes back to what I like to tell boards and councils, kind of down to the Baptist minister theory. You know, the church has all the money it needs. The bad news is it's in your pockets. So it does fall to user fees. But the bankers, in this case, whether it's the state or the federal government, looks at whether they can afford the loan or not, or grant. And so special districts are afforded the availability of the state and federal low interest and grant programs, loan and grant programs. So there is that viability issue, and we fight that every day. I applaud while I'm down here, State Land Investment and DEQ State Revolving Fund are presenting in Casper at a conference where they're going to start imposing asset management plans and hazard mitigation plans and requiring that applicants have to supply current rate information in filing for those state loans and grants, which will greatly enhance a lot of the things that I and my staff have been preaching about for decades. But I think what we're proposing does not affect any of the current statutes as it would relate to dissolution or viability, in the sense that it's still up to the banker and it's still up to the voters by electing those who represent them, just as municipalities do. And the municipality exemption was based on utilities only. And that's because of the user fee, and utilities are under governmental accounting are typically accounted for as if they're a for-profit type entity. They use the same accounting processes and procedures, just without the profit motive. So there's probably nothing that we're proposing would change any of your concerns from a commission standpoint. And keeping in mind that USDA has a less than 1%, I think, default rate nationwide, and the state of Wyoming similar. So there's really not that much risk in a municipal or a special district governmental entity.
Mr. Chairman, could I add one thing to that
Yeah,
answer
Mr.
that
Thompson,
might
go
help
ahead.
answer Representative Knapp's question? We need to keep in mind that no taxes are being pledged or used to repay these bonds. That would be a general obligation bond, and there would have to be an election for any entity in the state, city, town, or special district. We're talking specifically about revenue bonds that are based on repayment only from the user fees of the water or sewer service fees that would be generated from the system, so not from taxes. Thank you.
Representative Yin.
Mr. Chairman, thank you. Just to clarify, and I think I agree with that. You're saying that even if the special district implemented the system and then the board dissolved at some point, it would still not lay onto the tax revenue of the county. It would still only be paid back by revenue from the system itself. So the county taxpayers who were never part of the district board never are harmed by the dissolution of a.
Mr. Thompson.
Mr. Chairman, through you, that's correct. This is a special limited obligation payable only from the source, the revenue source that's specified in those bonds is not a general obligation and does not become the obligation of other taxpayers.
Senator Scott.
Mr. Chairman, we are talking revenue bonds here. And typically, if it's water, or sewer, something like that, you're going to have user fees, and that's where the obligation is naturally going to come. My question is, what's wrong with having an election on this? They're going to be voted on by the people whose rates are going to go up and who need the service. What are the practical problems of actually going ahead and holding an election on these?
Mr. Pepper?
Mr. Chairman, Senator Scott, typically bond elections have to be held according to special district election laws and bond elections, and that does not typically line up with the project timeline, is probably why the municipalities did the same thing. They have to be held during a general election year, during a general election year according to 22-29 or 22- one of the other stat. So the primary reason for that I think municipalities sought this exemption was because of that lineup of elections versus need. And the application dates that you have with the State Land Investment Board, with State Revolving Fund, with Wyoming Business Council, with Wyoming Water Development, all of those have deadlines of when you have to apply. And you'd also have, before you could actually hold the election, you have to know exactly what the people are going to be voting on. And in order to do that, they have to require and know what the rate increase is going to be along those lines. So all of a sudden you're delaying the project because it's kind of a catch-22. You have to know the final numbers before you can put it to a vote. The vote has to take place at certain times of an election cycle, which probably doesn't coincide with the deadlines that the funding agencies have in place. USDA does not have those kinds of timeline application deadlines, but as far as state funding, it presents that problem. And I don't have the legislative intent going back to 15.7.102C, but I got to believe that was probably one of the biggest things in talking with some of the municipalities, that the election dates and whatnot just don't line up. And going to a full election in this day and age, people know that they need if it's out of sight, out of mind. A lot of people don't realize that they have to replace the water line. I turn my tap on, the water's there. Why do I need to replace it? It's worked fine for 100 years. And hell no, I'm not going to vote for an increase in rates. But they have elected people who represent their interests, and they're the same people that are going to be paying those rates as well. So the boards, in my experience, do not take it lightly that they impose rate increases on themselves in these cases. But I think the primary reason is the lineup of election dates versus funding agency application deadlines.
All right. I think that's it. There's no additional questions for Mr. Thompson or Mr. Pepper? Nope. All right, thanks, guys.
Thank you.
Mr. Pickard, you're the only one in the room. You're left to testify. Are you sure? Okay. All right. Anyone else online? No? We'll close public testimony. Committee, is there a motion on the bill? Yep. It's been moved by Senator Boner and seconded by Senator Barlow. Any amendments on this bill? I believe Mr. Pepper had an amendment.
Mr. Chairman,
Senator Barlow,
Are you going to go page by page? Or you want me to just do a blanket amendment?
just go ahead.
Okay,
Yeah.
Mr. Chairman, so on page 3, lines 10 through 12, and on page 5, lines 18 through 20, strike.
Can you repeat it again?
Mr. Chairman, if I understood correctly, the subsection C under both of these sections
Is what you're deleting.
problematic.
Okay.
So I'm striking line 3, or page 3, lines 10 through 12, and page 5, lines 18 through 20.
Okay. Is there a second? Seconded by Representative Yin. We are just striking the subsection Cs.
Mr. Chairman, can we bring up Mr. Pepper again just to see exactly what they asked for? Because I know he spoke to some of the references very quickly, and I want to make sure that
Okay.
this is accurate.
Mr. Pepper, do we have it right, or is there more?
There's more.
I thought there was more, but I thought you were reinserting a section as well.
Correct. If, let me grab the. If I had my way, I would strike page 2, lines 14, and page 14 through 21. And then page 3, lines 1 through 12. Page 4, lines 21 through 23. And page 5 in toto, and replace it with the language contained in 15.7-102C. As a new paragraph B, so I would propose that we would replace on page 2, lines 14 through 21, with a new paragraph B, which is the 15.7-102C verbiage. And then on page 4, I don't know what it'd line up on paging at this point, but eliminating again under 4110-128, the current proposed paragraphs B and C, and inserting a new paragraph B, 15.7-102C language. If that's clear.
Mr. Plum's got it?
Yes, Mr. Chairman, if I may, just briefly. Yeah, so when I received this bill draft, right, it was just that one section, which is the same language as he said, 15.7-102C. But he had put it on a bill draft that had it candled out. And so that's just why this bill draft is candled out, but it's substantially the similar. It's just a little broken up different than how it is in one paragraph as it is currently in statute. And so, yeah, so if it was the committee's intention, it would be very easy to just swap out that language. It just doesn't have the B 1 and 2. It's all would just be 1B, but it's essentially the same language put
Gotcha.
together, if that makes sense.
Yep, that does make sense.
If it was friendly, we could do it all at once.
We like it when they're friendly.
But there's no pressure.
Mr. Plum, could you confirm again that 102C, 15.7-102C is the entirety of the language that you use to formulate the amendments in this bill? Or is there something more?
Mr. Plum?
Mr. Chairman, Senator Barlow. Yeah, so in the new bill, yeah, the B is just basically the language for funds borrowed from the United States of America, from the state of Wyoming, any subdivision, agency, or department thereof, any document evidencing that agreement to repay the borrowed funds shall not be considered a bond, and no election shall be required. Then the 1 and 2, and this is me kind of reading out of 15.7-102C. It's kind of taking those chunks of it, and then it's pulling out for 1 and 2 in 157102C, it's just a little more simplified, where it just says, sorry, I'm just trying to make sure I'm reading. Yeah, so where repayment of funds borrowed are to be made solely from revenues generated by the enterprise for which the finance public improvement project, and so it would be changing that to match with the language in the bill where it talks about the generated by the improvement or service with which that is from each specific district, as opposed to finance public improvement project necessarily, is associated and where security for the loan is restricted to a claim on the revenues generated from the enterprise. So it's just, in this bill draft, it just kind of expands a little bit on some of the language that's in Wyoming Statute 157102C when it breaks it out into 1 and 2. But the intent is, I guess, the intent was the same, to kind of have that same style of language.
Senator Case.
Well, Mr. Chairman, Mr. Plum, so what you're really saying is that your bill already does everything that this amendment would do?
Mr. Chairman.
Minus the subsection C.
Yeah.
Yeah, so minus deleting C. It does, from what I understood from Mr. Pepper and Mr. Thompson, is that, how the language kind of reads now, the repayment is solely to be made for improvements generated by the improvement or service with which it's associated. I think they thought that maybe some of that language could be somewhat limiting, but yes, the intention is the same.
If it's the same thing, I'd rather just delete C rather than rewrite the whole bill. No offense to Mr. Pepper, but it's just in the 11th hour right now. I'd rather not rewrite the whole bill if it does the same thing. Senator Scott?
Mr. Chairman, if that's how you're going to proceed, I'm no problem. The other part that Mr. Pepper was suggesting, he must be using a different draft of the bill than I've got. I was unable to understand what he was doing. This discrepancy we've got between the printed version and some electronic versions is a real problem, and we need to get that straightened out for the future.
All right. Representative Ottman.
Excuse me.
Thank you, Mr. Chairman. Just being new to all this stuff, I have a couple questions for clarification. Is that all right? Okay, Mr. Pepper, you're probably going to be the one to answer those, so would you come up, please?
Are you on the amendment?
Yeah, because it's the bill. Yeah.
Oh, it's not though. The amendment
It's
is
not?
only deleting subsection C right now.
Okay, you're just delaying.
Mr. Pepper's proposed amendment is the bill,
Yeah.
but we're not on that.
Well, this is a generic question, so you can tell me if I'm out of
Okay.
order, okay? Would that
Go
be
ahead,
all right?
Representative.
Okay. What I'm wondering is, are you desiring to have this done for a generic bill draft for special districts to be able to do this going down the road? Or is there a specific entity that's wanting this done? Or is there water and sewer already in place that this would improve? Or is this a place where the municipality doesn't provide, and so this would be this would be new service to people that they would, yeah, that's my question.
Mr.
Chairman,
Pepper?
Representative Ottman, there's no specific entity that's contemplated that would fix any kind of deficiencies. It's a generic move forward bill to correct what I see as an issue that has probably been overlooked many times in the past with special districts. Many special districts have state loans out there that probably were done without the benefit of a state or a district-wide election. And I think that probably was a hindrance in the municipality world. And so that was why it was corrected. I think at times we have some bills that go through that we think affects everybody. But in this case, it only affected municipalities. I'd like to think that we're going to do the same thing with special districts and just forgot to when it was done 15, 20 years ago. But this is just a correction to allow for the same, to put special districts on the same footing as a municipality is right now. But it won't, it'll affect it going forward. It won't, there's no specific entity that's contemplated or whatnot. There are, as Mr. Thompson indicated, I'm aware of 7 special district projects that were curtailed because of the requirement for the election through USDA. If that answers your question. Okay.
So, Mr. Chairman.
Senator Case.
Mr. Chairman, I would suspect that this would have pretty broad significance going forward as, more and more funds become available either through state sources or federal sources for infrastructure, these kinds of projects. So I would think it's going to have pretty broad use by saying clearly that they don't need to go back to the voters for authorization to do that. And that's the gist of the bill. There might be a philosophical thing there. That's the way I see it, is going forward, it would have a lot of use. They haven't had this authority in the past. We haven't seen it, and we don't have that many specific instances, but it would allow them to pursue funding that they haven't been able to pursue before. And Mr. Chairman, if we get past that one, I still want to go back to the repayment part and just clear something up totally.
Okay, Representative Ottman, are you good, or do you have a follow-up?
I'm okay for the moment. Thank you.
Okay, all right, please proceed.
I just want to be clear from the discussion from Mr. Plum and from, that if we get rid of Part C, if that's friendly, and we retain the rest of the language in the bill, I think I understand what the language about on page 2, lines 21 through 23 say. I can understand how Mr. Pepper understood that language. But are we clear that that allows for repayment from general revenues and not revenues from a specific segment?
Mr. Thompson?
Yeah, Ms. Thompson,
That looks
are
like
you
a
okay?
question for you.
Thanks, Ms. Thompson.
There we go. Thank you, Rick Thompson, Hathaway and Coons. I appreciate the intent to try to bring in that subpart C from the cities and town statutes into subparts 1 and 2, but the wording is a little bit different and causes me some concern. And it's on page 3, lines 6 and 7. The language in this bill reads, revenues generated from the proposed improvement or service. The similar language in the cities and towns statute reads, by contrast, revenues generated from the enterprise with which the proposed public improvement project is associated. That's a little bit different, and that's better language because it's clear you can pledge the water revenues of the district in that instance. In this new language, it could create some situations where it's unclear if they could do that, or if it's somehow you limit it to somehow trying to define the revenues to some particular improvement. While it may improve the whole system, someone could argue, well, that you can only do it as to a piece of it. And I don't think you want to go there. I think you want to keep it with that same language you have in cities and towns because it works and it's clear.
Ask a question.
Go ahead, Senator Case.
What if we just tweak that a little bit, sir, and take out the words "the improvement," so that it says repayment is to be made solely from revenues generated by the service with which the finance improvement of surface is associated. To me, that says if it's a water company, water revenues, it's not drilling it down to a specific segment. But I yield to you, sir.
Mr. Chairman.
Mr. Thompson.
Yes, thank you, Mr. Chairman. I believe that would be a good improvement to this bill, and that would do it.
Okay, and Mr. Chairman, Mr. Plum, what do you think? Yeah,
Mr. Chairman, Mr. Co-Chairman, I think that makes sense.
so that's a path to go forward, Mr. Chairman, as we
Okay.
take the bill and we take out subsection C, and we go into Romanet 1 on line 22 and strike the improvement or.
Well, on line,
That's line 22 on page 2. And then when you have to do the same thing on page 3.
oh yeah, I was on page 3. That's why I was confused.
It's, the language is doubled there, but you
On
have to do the
line
same thing
7.
on line 4. You'd have to take out improvement or. And I think that puts it all together.
Mr. Chairman, if I may, there's one more place on page 2. It's in line 6 and 7. Revenues generated from the proposed improvement, you'd need to strike it there as well. On line 7.
That's the old language, so we just.
And hopefully I'm not looking at an old draft of a bill.
It's 24 LSO 234. But just, Mr. Chairman, line 7 that you're talking about is existing language.
No, it's a different, but it's another one where the online copy is different.
Yeah, I'm not seeing the same line
Okay.
page you're seeing.
We have,
Because I'm looking at,
we're in a weird world in the LSO right now.
Mr. Chairman, Mr. Co-Chairman, unfortunately, yeah, this is it should be hopefully the last bill that is off. We did try to distribute a new one, but yeah, I believe it's on page 3. I think it's in the 1 and 2, like, right, so B 1 and 2. I think in paragraph 1, it's improvement or, it'd be repayment is to be made solely from the revenues generated by the service with which a finance improvement or service is associated. And then I believe Mr. Thompson is proposing the same thing for paragraph 2, which is the security for the loan or borrowed funds is restricted to a claim on the revenues generated from, and then you would delete we delete proposed improvement or, so it would say generated from the service or to a claim on the assets of the improvement or service.
So I get it now. I was going off an online copy. So Mr. Thompson, we're saying the same thing?
I think we are.
Yeah, I honestly do, but.
We are.
We were talking about different sections of the bill. So back to the original premise, if we fix those 2 places, regardless of where they are, and get rid of section C, we could go home.
well, there is that. Is it?
Mr. Chairman.
Senator Barlow.
Thank you, Mr. Chairman. So I think we're amending the amendment to include those 2 strikes. I would like, if I could, Mr. Chairman, to ask that those folks testifying about page 5, and I don't know what version you're looking at, but on mine it's page 5, and it's Romanet 1 and 2. And those are very different language as well than the chapter 15 language, because they talk about revenues generated from the acquisition, improvement, equipment, or project. And I don't know if we want to emulate the same language we'd have and just say service in some way. Thank you, Mr. Chairman.
Mr. Thompson?
Yes, Mr. Chairman, thank you. I agree. I think you need to have the same language in both of those so they're consistent with each other.
Maybe Mr. Plum could
I was
help
gonna-
us. Why
Mr.
couldn't we grab that earlier language and just drop it in for Romanets I and double I on page 5?
Mr. Plum?
Mr. Chairman, Mr. Co-Chairman, I was thinking the same thing. Yeah, just kind of copy.
Okay, it's gotten complicated, but hanging on here that if we're all off this paper copy that has new language we previously discussed, but also goes to what Senator Barlow pointed out on page 5. There's a Romanet on line 7, a Romanet little I. Line 12 is a Romanet double I. If we strike that language, and replace it with the same language from Romanets 1 and 2 as amended from the proposed amendment, I think we get it. And get rid of C. And maybe Mr. Barlow would consider that friendly.
At this point in the day at 5:12, Mr. Chairman, if I could, everything seems friendly.
Who's your second?
Representative Yin, you good? It was Boner, wasn't it?
Order was on the bill.
Oh, you moved the bill? You were in second? Yeah, it was,
Let Yen claim it.
felt like forever ago when that happened.
We could play the tapes, but I think Yen was the second.
All right.
And he's friendly. They're all friendly.
Does everyone understand the Barlow Yin amendment? I think we're good. As long as Mr. Plum understands it, that's my biggest concern.
Mr. Chairman, I understand.
You
Yes.
got it, okay,
I got it.
good. All right, all those in favor of the amendment signify by saying aye.
Aye.
Any opposed? That amendment has been adopted. Are there additional amendments to this bill?
I certainly hope not. They're very difficult at this point, but
All
I
right,
don't mean to discourage amendments.
I think we got it. Let's do a roll call vote on 24 LSO 0234, Special Districts Bond Elections Exemptions. Oh, sorry, Representative Ottman.
Yeah, I just want to say, considering all of this, apparently you guys get it, but with this, without being able to see it in order, and with so many deletions and lines and everything that I've done, I'm just for myself, I will be a no.
On the amendment or the bill?
The bill.
Okay.
So I'm happy to go through it again, Mr. Chairman, because I think when you actually track it in the bill after we get through it, I don't think it's that complicated. But perhaps it all can change your mind, but if not, I'd like the opportunity to go through it quickly.
All right, Co-Chairman Case?
So we take the bill, the paper version,
Yeah.
and we go to page 3, line 3, and we strike the words for which he struck the wrong ones here, sorry. For which financed service, we strike improvements or on line 3. We
There's a line 2 as
sorry.
well.
I don't have very good help. All right. Representative Ottman, you're probably going to be right in all of this, but it's page 3, line 2, strike the words improvement or, and page 3, line 7, strike the words improvement or. Lines 10 through 12, take all that out. And then the language that you're looking at right now with those 2 strikes, that Romanet I and that double I now become Romanet 1 and Romanet 2 now become substitute language for page 5, Romanet 1 and 2. And it's okay. That's just where we're at, in case anybody else had the same confusion. And we also have to strike the same C on page 5 for the same reason. So in the end, we have the stuff on page 5 matches the stuff on page 3, and we've taken out the concept of improvements, and we take out the C in both cases.
And Senator Scott, you're probably still confused because it's not the packet that was mailed to you, but a bill that was handed out to us here in person that you don't have.
And nobody anticipated this confusion about the line numbers. I'm sorry. Sometimes stuff just happens. Yeah. This is the online version that we were
Okay.
just talking about.
So
It's
it's the
not the
on-
version that was in your e-notebook. I'm not sure that Senator Scott is working from the e-notebook.
Senator Scott?
Caught him on that one.
Senator Scott, microphone.
Mr. Chairman, I'm working for the '05 version that was mailed to me. I don't have anything else, but I think I'm following it, and I think it makes sense. I do think we need to be to the point where we're all getting one bill, but that's a difficulty of having to be remote because of I didn't feel safe driving down there with my eyes being operated on. It's just a misfortune of having to put up with Zoom, and I think I'm all right with the bill, Mr. Chairman.
Next time we'll send a runner to Natrona County.
Mr. Chairman, that'd take too long.
Representative Ottman, did that help?
Mr. Chairman, it did some, thank you, Senator Case, but just for another point, for the repayment is to be made, right?
Romanet I,
Page 2,
page
which
2.
is going to be page 5. And then on page 5, 1 and 2 are gone. Is that it? They're replaced. So repayment is to be made solely from revenues generated by service with which a financed improvement is associated. So the service then would be the fees that people are charged.
Correct. These are revenue bonds. And so they're, in essence, the entity pledges the revenues from the stuff it sells. So that's what we're trying to say.
Okay, so if it's water sewer, then the fees for the water and sewer would pay the loan.
Yes.
Okay. Are these services, is this people that have like wells and septic systems that are going to be getting this? Or is this on the outside of municipality that already has water sewer?
Yeah, it'd be, Mr. Chairman, be some kind of a utility that's, so could be just a water service. Some people just have a utility just for water. Some people, and then they have septics. Some systems have, you can have just a sewer district and people could have wells, or you can have a water and sewer district, or you can have separate water district and a separate sewer district. But either way, this allows them to obtain these funds and pay them back by pledging, or obtain the funds by pledging the revenues from what they sell.
And one more follow-up, please. Okay, so the water and sewer service fees will be what pays for the advancement of this project. So we aren't setting it up for federal funding, possibly that could come through the Department of Ag or something like that down the road. We're looking at this to be fees, or?
Mr. Chairman?
Senator Case.
It might be fair to say that this is what's pledged. That the owner of the bond says, I've got this bond and you have pledged revenues from what you sell to cover these bonds. Now, it doesn't mean that the district couldn't get more money from another way and pay off the bonds. But legally, when rubber hits the road and the bonds, the court is involved, all the bonds have a claim to is the revenue stream. Now, lots of times entities retire bonds early. You get a windfall of money and the bonds might be very favorable circumstances. So you could take a grant and retire the bonds, I suppose, or there might be the district sold some property and had some property extra to retire bonds. I mean, there are different ways that they could be paid, but the claim of the person holding the bonds only extends to the revenues from the service that's underlying it. Is that fair? Did I do okay? to my council?
Mr. Chairman, that was a perfect explanation. I want to add one very minor nit. You had correctly said to strike improvement or on line 7, but I believe the word proposed also needs to be stricken because it was part of that proposed
friendly.
improvement or.
If it's friendly to everybody else.
Okay, Mr. Plum's got it. All right, now we're ready to vote. Let's do a roll call vote.
Roll call on 24
Whoa,
Ellis.
oh.
Mr. Chairman, I just had one comment before the vote. I appreciate what's trying to be done here, but I think we talked about a philosophical question, and that's the entire bill. The philosophical difference to me is the right for those end users to have a say in whether they want to participate in what will be a fee increase. And their ability to say that is through a vote. And I just have an issue with, with entities, the less assets you have, the less financial capability you have, it is even more important to have buy-in from those residents and to be able to vote on that. So for that reason, I am going to be a no vote on this.
Thank you, Representative Knapp.
Mr. Chairman?
Senator Case.
I agree with you for the most part, but if a repayment required an increase in fee, I'm sure that the person giving you the bonds would require that the fee increase be implemented contiguous with getting the bonds issued. So that means they'd have to go through the approval process that the board would have for that fee increase already. And I'm not sure how that works, but they'd have to legally raise the fees in order to connect with the bonds, or they're not going to get the bonds, I would imagine.
Mr. Chairman, may I-
Mr. Thompson.
Yes, thank you. Typically, there's no fee increase involved. And the one I explained to you, all they were doing is they were adding users to the subdivision. So it's got the potential to lower rates
I
because
see
you
that.
have more users sharing the system. So typically, there's no increase involved with these bonds. Any increases would happen how they normally do outside of anything you're doing on the bonding front. You're just pledging those revenues as a source of repayment, as the source of repayment for the bonds.
And so you're growing the system and achieving lower costs.
In most cases, that's exactly what's going
Okay,
on.
thank you, Mr. Chairman, sorry.
Representative Wiley.
Another good thing to keep in mind is this is exactly the same as how all the municipalities are doing it currently. This is just putting it on a level playing field if we talk about equity.
All right, anyone else want to explain their vote or explain to others how they should vote? Nope. Okay, question. This is really it.
Mr. Chairman, roll call for 24 LSO 0234, special districts, bond elections exception as amended. Senator Barlow? Senator Boner? Senator Landon excused. Senator Scott?
Aye.
Can you clarify?
Aye.
Thank you. Representative Chadwick? Representative Harrelson?
No.
Representative Harshman excused. Representative Knapp? Representative Newsom? Representative Ottman? Representative Wiley? Representative Yin?
Aye.
Co-Chairman Case?
Aye.
Co-Chairman Olson?
Aye.
9 aye, 3 no, 2 excused.
And Representative Ottman, you'll be floor managing that. No, I'm just kidding. LSO has asked me, Senator Scott, if you could clarify your previous vote on 24 LSO 0100.
Which was?
Our previous bill, the special district vacancies. Senator Scott, can you clarify your vote on that?
Mr. Chairman, I voted aye.
Thank you.
Mr. Chairman, a housekeeping,
Yes,
normally, you're not going to be here for the last day tomorrow.
right.
And normally committees either do one of two things. That, you know, we have bills that are out there, we haven't established which house they're going in. Typically, this Corporations Committee has allowed the chairman to get together after the meeting and and decide where the bills are going.
That's how I've done it in the
Yeah,
past too.
and so if that's okay with the committee, but if that was not okay, I thought you should hear it. So
Okay.
that would be with a proposal when we get done tomorrow, and you're not going to be here, but if
Yep.
you're okay with that.
I'm okay with that. I was kind of assuming it. Any objections, committee? I will not be here tomorrow. I apologize in advance. I have a funeral that I have to attend across the state, so I won't be here.
Safe travels, Mr.
All right. Any other staff directives or clarifications? Anything, staff, that you need from us before we adjourn for the evening? Nope. Okay.
8:30.
We're adjourned. We'll see. I guess I won't see you, but we'll be here back at 8:30.
Drive.